The Royal Commission is now in session.
Good morning, everybody, and welcome to those who may be in the hearing room in Adelaide or are following these proceedings on the live stream. I'd like to commence by acknowledging the Kaurna people of the Adelaide Plains, the traditional custodians of the land on which the Royal Commission is holding its hearing in Adelaide this week, and to pay my respects to their elders past, present and emerging. I also acknowledge the Gadigal people of the Eora Nation, upon whose lands I am participating in this hearing, and the Wurundjeri people of the Kulin Nation, from whose lands Ms Elizabeth Bennett of Council is appearing. I pay our respects to their elders past, present and emerging. I also pay our respects to all First Nations people who are attending the hearing in person today, as well as to those who may be viewing the hearing on or following the hearing on the live stream. Yes, Ms Bennett.
Thank you, Chair. The first witness this morning is Mr Anthony Allwood, who I believe appears in the South Australian hearing room to be sworn or affirmed.
Yes, thank you very much. Thank you, Mr Allwood, for coming to the Royal Commission to give evidence. If you would be good enough, please, to follow the instructions of the associate who is in the same hearing room as you are, and she will administer the oath to you. Thank you.
I will read you the oath. At the end, please say yes or I do. Do you swear by Almighty God that the evidence which you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
And just for the purposes of orientation, Mr Allwood, in the hearing room with you are Commissioners Bennett and McEwen. I am participating in this hearing from our Sydney hearing room, and Ms Bennett of Council will be asking you some questions from Melbourne. And Ms Bennett will now ask you some questions.
Thank you, Chair. Could you please tell the Royal Commissioners your full name and address? I'm sorry, not your address, I'm sorry, just your full name.
Yes, it's Anthony Allwood.
Thank you. And you've made a statement for the Royal Commission dated 13 May 2020, is that right?
Yes, I have.
And have you read that statement recently?
Yes, I have.
And are the contents of that statement true and correct?
Yes.
All right, thank you. Now, I'd like to just understand a little bit about your role. You're the manager of the internal audit team, is that right?
That's correct, yes.
So I understand you carry out audits generally by the review of records and systems, is that right?
Yes, that's right. Records, systems, discussions with staff, observations, yes.
And is that process one that is carried out primarily focused on identifying defects or faults in processes and procedures?
That's correct, yes, and also opportunities to improve.
And those opportunities to improve, are they focused on policies and procedures or on broader issues?
It can be on anything. It's primarily on policies, procedures and systems, but it can be on broader matters.
Do your audits encompass issues of overall culture and compliance?
Sorry, could you repeat the question, please?
Do your audits encompass things like workplace culture?
Yes, if that's a focus that comes to the fore during visits, then that is something that we would look into further.
Is that something you need to be directed to look into, or is that part of your usual audit function?
It can be a part of the objectives of the audit, which is agreed with the audit executive of the auditee area, or if it's something that we identify during the course of an audit, then we would pursue that if we felt that was appropriate and relevant.
And is that something that arises in the course of discussions with staff?
Yes.
Is that that can arise?
Yes.
And so is it, yes?
So yes, it can be, or it can be in advance, sort of when we're preparing to go out for an audit. The auditee executive may suggest that there's potentially an issue with culture that it would be helpful to have independent eyes look at.
I see. Now you said independent eyes. Can you tell the commissioners about your independence?
Yes, certainly. The internal audit team is an independent role within DHS. Clearly we're part of DHS. However, Our reporting lines are directly to the Chief Executive and to the Chair of the DHS Risk Management and Audit Committee. I do sit for administrative purposes in a business division, but I do not report to the Executive Director and Chief Finance Officer on audit matters.
So you report to the CEO. In what sense are you therefore independent?
Sorry, could you repeat the question, please?
Are you not obliged to comply with the CEO's directions?
Yes.
Okay. So how do you see your role as being independent?
We're not a part of, because we're not a part of a particular business function, we can identify from records independently. We have unlimited access to records, information and people, and part of the internal audit profession's requirements are that our reports and findings are supported by evidence. Therefore, we report what we find, and that can't be influenced by by the Chief Executive, for example, which is why there's a dual reporting role to the Chief Executive and to the Chair of the Audit Committee.
All right. I'm going to ask you a couple of questions about a site we've been referring to as N Street. Are you aware of what I'm referring to
Yes.
when I say N Street?
Yes, I am.
Now, we mentioned yesterday that there are a cluster of sites next to and around N Street. If I need to refer to them, I'll refer to the N sites. Is that okay?
Yes, thank you.
Okay, thank you. Now, I want to ask you about your audit report, which appears at Bundle B, tab 36. It's dated January 2019.
Yes.
And it is said to be from you to Muriel Kirkby. Do you have that document?
Just bear with me one moment, please. Yes, I do.
Now, this was part of an internal audit program of rolling unannounced visits to accommodation sites. Is that right?
That's correct, yes.
And the N sites were some of the N sites had been selected for unannounced visits. Is that right?
They were selected after I'd had a discussion with Muriel, who very early on in the piece, the programme of site visits commenced in mid-December, and late December I had a chance meeting with Muriel and a discussion as to how the audit programme was going, and at that point I asked if there were any sites that were of particular interest or concern that Muriel or her team would like me to arrange for a visit in the near future.
All right. And so did you understand there were any cultural concerns around the N site?
In that discussion, Muriel mentioned that she had concerns around the culture and also the number of incidents that were being reported from that site.
When you say number of incidents, do you mean injuries?
Riskman incidents reported on the Riskman system, the incident reporting system.
There was a disproportionate number of unexplained injuries from the N site, wasn't there?
Without looking at the statistics, I can't remember, but certainly the...
Well, perhaps you could have a look at your report in front of you at page 5, and at the final paragraph it says unwitnessed injuries.
Yes.
Incidents relating to unwitnessed or unexplained injuries account for 193 or 20.8% of all reported incidents for
Yes.
the 3 sites with clients at N Street, accounting for over half,
Yes.
104 of those.
Yeah.
Was that part of the concern that was raised with you, unexplained injuries?
Not explicitly, just the number of incidents in general, which enabled us to look at the whole range of incidents that had been reported. The comments that I made...
Of the issues, yes.
I'm sorry?
And that was one of the issues that arose in the course of your audit, is that fair?
That's correct, yes.
Yes, thank you. Returning to the first page of your report, you visited the N Street accommodation service, is that right?
2 of my senior internal auditors did. Yes.
Yes. You tell us that at the bottom of page 1, you tell us that upon entering the site, there is a strong pungent odour of urine in the main living area. Do you remember that?
Yes.
You tell us further that the carpet had not been cleaned in 2 years, despite funding having been approved for that task. Is that right?
That's correct.
Did you hear Ms Kirkby's evidence yesterday?
Yes, I did.
You heard me ask her if the end site had an air of neglect about it. Was it your impression from your observations recorded in this internal audit report?
Yes. Yes, the auditors who visited did find it to be rather sparse, probably in need of decoration, and as you just pointed out, the smell of the carpet when they walked in.
Yes. And there was no explanation for why that approved cleaning hadn't been carried out?
As to why it hadn't been carried out, no.
Right.
No.
Is it fair to say that that was not a particularly home-like environment?
Sorry, a high?
Home-like environment.
Yes, I think
like a home.
That's a fair comment based on the observations the auditors made, yes.
Yes, thank you.
Thank you.
Right. I'd like to ask you a little bit about, I'd like to turn now to the circumstances of the investigations around Mitchell.
Yes.
Now, have you heard the evidence this week concerning the letter received by Mitchell's family?
Yes.
So you heard from James and Victoria and giving their evidence?
Yes.
And you've read the letter that they refer to?
Yes, I have.
All right. Now, you have provided, the Royal Commission has received an internal audit report authored by you dated 2 June, and Commissioners, this appears at Hearing Bundle B, tab 41A.
Yes.
Now, this, as I said, was provided on 2 June 2021. Can you tell me when you were asked to carry out this audit?
Yes, I was approached on the 6th of May.
And what were you told about the reason that you were being asked to carry out this audit?
It was to have a look at how the department had handled the incident around receipt of the anonymous letter, how it was investigated.
Well, you say at audit scope and objectives that your objectives are listed there, including review the actions taken by the department in response to concerns raised by Mitchell's guardian in March 2018 and determine whether the response and the resulting communications were timely, appropriate, in accordance with defined policy and procedure. You see that?
Yes.
And is it fair to say that you concluded that the response was not timely or in accordance with policy and procedure?
Yes. Yeah.
And then you were asked to determine whether investigations into the concerns raised were adequate, timely and performed in accordance with defined investigation procedures, and whether actions had been taken in response to issues raised by the South Australian Ombudsman's letter and the effectiveness of those actions. Is that right?
Yes, correct.
What I want to understand, Mr. Allwood, were you asked to evaluate whether the second investigation carried out was actually useful in trying to identify the author of the letter?
I was asked to have a look at whether the second investigation addressed the issues that were raised in the Ombudsman's letter, in that the first investigation was felt not to be adequate and that a follow-up occurred.
Yes. Can you see the distinction I'm drawing? The Ombudsman made criticisms. I'm going to go through this to be clear in a moment. So let me just see if I can summarise the timeline correctly so that it's clear for those watching. The letter, the threatening letter, and you'd agree with me it was a threatening letter, wouldn't you?
Yes. Yes, I
That was
agree.
received on the 3rd of March 2018. And
Yes.
then there was, according to your document, some undocumented inquiries made in March of 2018 around that letter. Is that right?
Yes, correct.
And we're not sure exactly the content of those inquiries or how fulsome they were because they weren't documented.
That's correct. I've not been able to
And that's
find
what-
any evidence.
And that's one of, sorry.
I've not
And
been
that's
able,
one of the-
not been able to find any evidence of a record of those discussions.
And it was referred to the internal investigation body only in April 2018, some 6 weeks later.
That's when the Incident Management Unit actually commenced their investigation. The then director of the Incident Management Unit was involved, I believe, on the day that the actual letter was received.
Yes, and they commenced their investigation some 6 weeks later, and they completed it on the 28th of November 2018, and that's the first report. Is that right?
Yes, that's what I found, yes.
And that's the first report that you found to be defective. Is that right?
Yes,
And that's consistent with the findings of the South Australian Ombudsman, that that report was defective.
that's correct, yes.
And if I can put it another way, would you agree with me that the first report didn't do all things that could have been done to try and find the author of that letter?
Yes, I agree. The focus of the investigations that the Incident Management Unit undertook sort of from April onwards focused elsewhere and not directly on the trying to identify the author of the letter.
And if I understand your report, in fact, they focused a lot on the conduct of James and Victoria rather than on the author of the letter. Is that fair?
That's correct, yes. There are records of an interview that the director had with James, the director of IMU at the time had with James, in which James did mention a couple of times, he expressed his view that finding the author of the letter was not the key concern, but that Mitchell's safety was the primary issue and the concern that they had around the staff being made to read the letter out.
Yes, and so those are matters that, if I read your report correctly, that diverted
Yes,
proper attention of the investigators from their proper task onto other matters. Is that right?
that's correct. I believe there was
And to the detriment of the report overall.
to the detriment of finding the anonymous letter author, yes.
Yes. Yes, thank you. All right, so then to move on with the timeline, then the South Australian Ombudsman investigated. There was a process of investigation and the Ombudsman released its final report. There was a preliminary report in September of 2020 and then a final report on 27 January 2021, which found the first report to have been deficient. Is that fair?
Yes,
And the Ombudsman identified those deficiencies at around paragraphs 151 and 152 and identified a number of investigative steps that could have been taken but were not taken. Is that right?
yes, yes.
Now, there was then a further investigation, I'll call this the second investigation, that was carried out after the Ombudsman report. Is that right?
Yes, correct.
And that second investigation is dated February 2021. Is that right?
Yes, correct.
Okay. And it's the second investigation that you were then asked to report upon. Is that right?
I was asked to report on all of them, on the investigation.
Oh, sorry. Yes.
On the initial investigation and how that was handled into the anonymous letter, and also the second investigation in terms of whether that addressed the Ombudsman's finding.
Yes. And that's brings me back to my earlier question. Does your audit report of 2 June consider the question of whether the second investigation was actually effective at trying to find the author of the letter, or is it directed at determining whether the second report complied with the Ombudsman report?
It was, I think, partially both. it was certainly a consideration as to whether it had addressed the Ombudsman's finding, but I also had a look at whether the second investigation actually considered staff that had been identified in the first investigation that hadn't been pursued in that first investigation.
So when you say it's a little bit of both, is it the case that it wasn't completely an investigation into that question, or it wasn't completely a review of that question?
Sorry, I'm not quite sure I understand.
Oh, all right. No, that's okay. All right, so are you able to tell the Royal Commission if you consider the second investigation to have been adequate and appropriate to identify the author of the letter?
Yes, my opinion is that it was adequate given the time elapsed. It did identify more staff to be interviewed, and some of those interviews were carried out. But given the time elapsed, it would be unlikely to find anything that didn't necessarily come up earlier.
All right, well, I'd like to test that with you. Can we go to the second report? It's at Hearing Bundle B, tab 48. Now, if you have that at page 2 of 7, as it stands at the bottom of the page, the scope of the investigation. So this report has 3 headings in it. The first is background, which sets out some uncontroversial matters, and then the scope of the investigation is set out. And that is said to be to obtain statements from staff working at the site at the time in relation to the points above. A roster of staff working has been sourced and statements have been taken from those staff members where possible. You see that?
Yes.
That was the scope of the second investigation, wasn't it?
Yes. Yeah.
That does not say that identifying the author of the letter was the purpose of the investigation.
Yes.
Does it?
No, it doesn't. You're right.
Is it fair would a reasonable reader conclude that this investigation was directed at obtaining statements and taking additional statements?
Yes. Yeah.
And the statements that the additional statements that we're guided by a roster of staff working, and we're told that the roster of staff, the third footnote, were for February and March 2018. Do you see that?
Yes. Yep.
Now that's a very confined time period, isn't it?
It is, yes.
And the Ombudsman observed that it was likely to be necessary to consider people who had worked with Mitchell over a far longer period of time. Was that not the case?
Yes. Yep.
And in fact, the evidence in the first investigation was that the writer of the letter used a nickname for Mitchell that had been in disuse for some months, if not years. Is that right?
Yes, correct.
So can you tell me whether or not confining consideration of the staff to a 2-month period around the time of the letter was a useful or appropriate means of approaching that investigation?
I believe there was opportunity to look at a broader range of staff. Initially, it was suggested that there could have been up to 100 staff that could have been interviewed, so it would be a pragmatic approach to try and limit that initially.
Well, can I just pause there? Where do you get the idea that any decision was made to limit to a 2-month period because, for any reason at all?
I haven't. That's an assumption that I've made because that was the rosters that were available.
Well, there were more rosters than that available, weren't there?
Yes.
And Riskman reports were available for a much longer period, weren't they?
Yes.
And we were told yesterday that they include input auditing capacity. So we can check who has entered matters into Riskman and who hasn't.
Yes.
As far as I can see from this report, rosters for only 2 months were considered. No Riskman reports were identified over a longer period, and rosters that were available were not considered. Isn't that right?
Yes.
Now, I'd like to suggest to you, Mr. Allwood, that that is deficient as an investigation. Would you agree with that?
Yes. Yep.
Thank you. Now, the heading to the next heading says summary of evidence. I'm not going to take you to this in detail, but would you agree with me that the summary of evidence is no more than a short form summary of the 8 interviews carried out with available staff? Is that a fair characterisation?
Yes.
Yes.
Yeah.
And then at the end of that, we have a heading that says additional information, and that additional information refers to the identification of some people who could not be identified or who could not be contacted or who did not respond to contact. And in the second paragraph under additional information, and I'll ask the operator not to bring this up for privacy reasons, there are identified 3 people who were not contacted because they were the subject of previous investigation in 2018, I interpolate, and provided their responses then. That's right?
Yes. Yeah.
Now, just to pause there for a moment, wouldn't good investigative practice be to interview again the individuals from 2018 in light of the additional information?
Yes.
And that wasn't done in this instance?
I can't remember, to be honest.
Well, if you have a look at that paragraph 2 under additional information, it says, it names 3 people, and then it says that they have not been contacted in this instance as they were subjects of the previous investigation and provided a detailed record of interview at the time. That's what it says, isn't it?
I can't see the document. I can't see the document,
so
but if that's what you've just read,
okay.
yes.
So you'd agree with me that a decision was made by the investigators not to re-interview people from the 2018 investigation in light of additional information?
Yes.
And we're nowhere told where or why that decision was made, other than they had provided a detailed record of interview at the time.
Yes.
Now, you're an experienced investigator and auditor. Is it not the case that these people should have been spoken to in light of subsequent information?
This should certainly have been considered to determine whether any additional information would be available or whether the original statements were sufficient.
Yes, thank you. Now, that is the end of the report. Would you agree with me that there is no analysis of the information provided?
From memory, yes.
Well, feel free to take a moment. I mean, it's a serious matter, Mr. Allwood. I don't want to put words in your mouth. Is there any analysis in this document?
Which document are you referring to?
Sorry, Ms Bennett.
The investigation report?
Sorry, Ms Bennett, the witness does not have the documents and will provide a hard copy if you don't want certain things to come up on the screen. So just give us a moment.
I'm sorry. I didn't realise. I'll ask.
But we'll just take a moment until
Yes.
that document is provided. Thank you. I think
Thank you.
Mr. Allwood now has the document, so could you, Ms Bennett, indicate what you would like Mr. Allwood to do with that document?
Thank you. So, Mr. Allwood, if you could have a look, I've just been through, you'll see on page 2, background, scope investigation, summary of evidence. Do you see those headings
Yes.
on page 2?
Yes.
And then we were up to additional information, and we've been through the second paragraph under additional information.
Yes.
And then I suggested to you that there is no further heading of substance in that report.
Yes.
And I suggest to you that there is no analysis of the evidence in this report.
Yes. Yep.
There is no analysis of how the information obtained in the second investigation might relate to or fit in with the information from the first investigation. Is that right?
Yes. Yep.
There is no timeline of events, no chronology, no identification of key players. Those are all missing, aren't they?
Yes.
And they are all things that you would expect to see in a competent and proper investigation, aren't they?
Yes.
Yes.
Yep.
I put to you, this is not a proper and competent investigation. Would you agree with that?
Yes. Yep.
Yes, thank you. All right. There's another matter I'd like to take you to in your audit report. If I could take you back to that document, your 2 June 2021 audit report. Now, can I take you to page 4 of that document? There is a heading there, investigation of anonymous letter.
Yes.
You see that?
Yes.
Now, can I take you to the 5th dot point, starting with the words, no records have been identified?
Yes.
I'm just going to read it out for the sake of clarity. No records have been identified to indicate that an IMU resource was assigned to undertake an investigation at this time. Now, just to pause there, based on context, I understand that to be a reference to March 2018, shortly after the letter was received. Is that right?
Correct. Yes.
Okay. I'll return to reading. Further, a statement in the IMU investigation diary for the second, brackets, January 2021, close brackets, investigation into the letter records that, and I'm quoting, clear instructions were given to the investigator at the time from the director, ... not to follow up on establishing who the author was. Now, can you tell me what you understand that diary entry to be?
Yes, that's a record from the investigator who undertook the January 21 investigation, who was gathering information from the initial investigation file and recorded that comment in the investigation diary.
Mr. Allwood, I read that to be a record of the director giving an instruction to the investigator not to follow up on establishing who the author of the 3 March threatening letter was. Is that how you read it?
Yes, however, I would add there's context in that prior to the initial investigation being undertaken and commenced in April 2018, the then director of the Incident Management Unit had met with James, and at that meeting, James had indicated, according to the notes of that meeting made by the then director, James had indicated that he was not concerned about the letter or identifying who sent the letter. And the evidence in the investigation file suggests that, as you indicated earlier, the investigation then focused more on the complaints raised by Victoria and James, rather than the finding the author of the anonymous letter.
Is it a matter of concern to you that the director could have given such a direction to the investigator?
Yes. However, it doesn't...
It's a significant concern, isn't it?
Yes. However, it is within the context, and in my opinion, there were at least two matters to be investigated, which should have been done separately. One was the matter of the anonymous letter, and the other was the complaint against the staff made by Victoria and James.
Isn't the only context that matters, Mr. Allwood, that a threat to the life of a vulnerable person had been made? That ought to have been the guiding priority for the director, isn't that right?
Yes, I agree. However,
wouldn't a clear instruction like this be a breach of policies and procedures of the department?
I can't answer that. I don't know.
Leave aside a specific piece of paper.
Yep.
I'm putting to you that the primary concern of everyone involved in the disability accommodation services should be for the safety and well-being of the people who live in those services. You'd agree with that?
Yes, I do. Yes.
No one needs a piece of paper to tell them that, do they?
No. No.
And so a clear instruction not to follow up on who the author was improper, wasn't it?
Yes. However, I would come back to the point that was made in the discussion where James had commented that finding the source of the anonymous letter was not a priority, and also the fact that the matter had been reported to the police and that the then director of the Incident Management Unit was of the opinion that the police should be investigating that matter. At the time, there was no strict direction in place as to whether the Incident Management Unit could investigate a matter that was being handled by the police. That has been rectified in a recently introduced procedure.
Can I suggest, Mr. Allwood, that even now there is a tendency to blame James for the inaction of the department? Would you accept that?
No, I don't believe that's the case. I believe it was a contributory factor, the meeting that he had. I can only report on the evidence that's in the investigation file.
I understand that, and you've been frank in your evidence, and I'm grateful for that. But what I want to put to you is, whatever James said doesn't matter to the duty of the department to follow this up. Would you agree with that?
Yes, certainly the investigation could have been done better. Yes.
Well, no, I'm now focused on this direction. Was your audit report of 2 June the first time, to your knowledge, that this direction has been ventilated?
It's the first time that I've seen it. I can't comment on who else might have seen the document outside of the investigation incident management unit.
Doesn't it? Are you aware of any plans to carry out further investigations in relation to this issue?
At this point in time, no, I'm not aware of anything.
Has that prompted you to consider whether or not there need to be cultural investigations into the staff at the department in this area?
I hadn't given that explicit thought.
Well, doesn't this suggest that there was a culture of non-compliance at the time?
In regards to who? Sorry.
In regards to the director and the investigator, or at least the director giving that direction.
Sorry, can you go back to your question? Sorry.
Well, does this direction suggest a culture of non-compliance, a culture of disregard for safety, a culture of concern in the accommodation services?
It's an incident. It's one incident on its own.
How do you know?
Yeah.
What if it's not an isolated incident? What if this is emblematic of the culture at the place and the time?
Yes, that's a good point.
Is anyone, and this brings me back to where I began this morning, when does the culture of the institution as a whole come up for examination? When do we look past the piece of paper and ask, are the people acting in the best interests of the clients?
Culture is something that we try and look at when the internal auditors go out and visit sites in terms of their observation of interaction with clients, of staff, and the interaction, the contentment of clients.
Can I take you to paragraph 51 of the statement of James? I'd like to ask you about this. I'd like it to be brought up on screen so that you can read it. I'm sorry, I stepped away from the microphone. Can it be brought up on screen so you can read it? Can you let me know when it's on screen in front of you?
Not yet.
Well, that's for the commissioners. This is in hearing bundle A behind tab 29.
I'm
Thank you.
grateful to my leader.
I think it just, on the screen, it just needs to turn to page 10. It's currently on 1 of 14.
Have you read that paragraph?
Yes, I have. Thank you.
Now, you talked about the context before being relevant to the director's notation in the investigation notes.
Yes.
Now, this is quite a different context, isn't it?
Yes, it is.
Now, this is James's version of events, and he says he understood that there was an investigation being carried out and that, in summary, he didn't need to know who the person was as long as someone did. Is that a fair summary of that paragraph you've just read?
Yes. Yes.
Now, if that were the case, there would be no context at all that mitigates in relation to the paragraph I've just taken to you to, the diary note that I've just taken you to.
Yes.
It would it be right to say it would be improper on either view, but particularly so if this version of events were correct?
Sorry, could you repeat the first part of that?
Well, that notation, that direction would be improper, irrespective of the context. Whether or not James wanted an investigation or not, that direction was improper. Is that fair?
Yes.
If James's version of events is correct, then it would be even more improper. Is that fair?
Yes.
Now, Mr. Allwood, I've asked you some questions about the second investigation report, and in your answers, you've, I think, fairly departed somewhat from the conclusions that we find in your internal audit report of 2 June 2021. Is that fair?
Yes. Yep.
And are the commissioners to take it that to the extent that there is a difference between your audit report and the evidence that you've given today, they should prefer the evidence that you've given today?
Yes.
Yes. Now, just a moment. I'm going to see if there are other matters to raise. Those are the matters I sought to canvass with Mr. Allwood this morning, Commissioners.
Thank you very much. I'll just inquire, Mr. Allwood, whether commissioners have any questions. Commissioner Bennett, do you have any questions of Mr. Allwood?
No, Chair.
Thank you. Commissioner McEwen?
No, thank you, Chair.
Thank you. Now, I think that there is, in fact, another appearance, is there, to be announced today that I haven't yet taken?
Sorry, Chair, just before we get to that, our colleagues from South Australia would like an opportunity to have a short adjournment to determine whether or not they need to follow up any questions in relation to Mr. Allwood's evidence. So could the Royal Commission accommodate us to do that?
Yeah, that's fine, but I think there is another appearance, isn't there, for South Australia that hasn't yet been taken, I was told? No?
No, I haven't been told that, but I'll make those inquiries in the short break as well.
Right. How long do you want the break for? Or more accurately, I suppose, how long does South Australia want the break?
What we might do is, I've noticed that it's 11:15. If the commissioners are agreeable to perhaps an early morning tea, we can take an adjournment now for 20 minutes. And I'll let the commissioners know after speaking with our learned friends as to if they need more time and also whether or not Mr. Allwood will be released.
Yes, all right. Well, we'll adjourn then until 11:05 Adelaide time. Thank you.
Thank you, Chair.
The Royal Commission is adjourned. The Royal Commission is resumed.
Yes, Ms Eastman.
Thank you, Commissioners, for that early morning tea. I understand there's a few questions that arise directly out of the examination the Council representing the State of South Australia would like to address. And having conferred with him, those questions seem to be appropriate and directly related to the evidence.
Yes, thank you. Mr Golding, is it, who will ask those questions?
Mr Simpson, sorry, Chair.
Yes. Where does Mr Golding appear? I seem to have an appearance from Mr Golding. Is this something that has mysteriously emerged from the atmosphere?
No, Chair. Mr Golding appeared at the public hearing in South Australia in November of last year. I am in fact Mr Golding's junior, but Mr Golding was otherwise indisposed for this week's hearing.
Very well, that clears it up, except that I'm not sure we had a hearing in South Australia last November, but never mind. Yes, please ask your questions.
Thank you, Chair. Mr Allwood, in your evidence that you've given, you gave some answers to questions that related to instructions that were given by a director in relation to the scope of the investigation. Can I ask you, did those instructions relate to the first investigation or the second investigation?
Those instructions related to the first investigation.
And in that first investigation, notwithstanding those instructions, were efforts made to attempt to identify the author of the anonymous letter?
Yes, during the interviews conducted by the investigating officer from the Incident Management Unit, the staff that were interviewed were asked as part of the interview process whether they were aware of the author of the letter.
Now, in your report dated earlier this month, you undertook some investigations in relation to the focus of the first investigation in relation to safety of Mitchell. Are you able to comment on that?
Yes, I did find evidence of emails and correspondence which indicated safeguards that were put in place to protect Mitchell. They included, if I may read, hourly welfare checks. A supervisor was placed on site over the night shift, and efforts to maximise the use of core staff that were trusted by the by the family and the client to roster.
Mr Allwood, where are you reading from, please?
My report of the 2nd of June, page 3, section 2, safeguard arrangements for the client.
Thank you.
Chair, that can be found at...
Yeah, I've got that. I just wanted to know where Mr Allwood was reading from. Thank you. Carry on.
Sorry, Mr Allwood, had you finished your response to that question?
Yes, thank you.
Thank you. Now, turning to the second investigation undertaken by DHS, at tab 48, there's the second investigation report that you were referred to. And the first, on that first page, there's a heading that refers to the scope of investigations. That scope refers to dot points above. I understand that to be reference to the 3 dot points that appear in the last paragraph under the heading background. You were asked, Mr Allwood, some questions about the scope of the second investigation.
Yes.
If you just take a moment to read those paragraphs together.
Yes.
Are you able to comment on the scope of the investigation, the second investigation, insofar as it relates to attempting to identify the author of the letter?
Yes, the scope of the investigation clearly needs to be read within the context of the paragraphs above, which does refer to identifying the author of the letter.
Thank you, Mr Allwood. Chair, I have no further questions.
Yes, thank you very much, Mr Simpson. Yes, does that mean that Mr Allwood could now be excused, Ms Eastman?
Yes, it does. Thank you, Chair.
Yes, thank you very much, Mr Allwood, for coming to the Commission and giving your evidence this morning. You're now excused as a witness, so you're free to go or stay as you wish. Thank you very much.
Thank you. Thank you.
Yes, Ms Eastman.
Chair, I think we've also got to the bottom of the additional appearance, and Mr Simpson might want to address that.
Yes.
Chair, I appear for Ms Gale in her capacity as public advocate and principal community visitor, in addition to appearing for the state.
Yes, thank you, Mr Simpson. All right. Is there any other person or any other witness for whom you have instructions to act other than the State of South Australia and Ms Gale?
I appear also for the witnesses from the Department of Human Services for the State of South Australia. That had been communicated to solicitors instructing, but I apologise if that wasn't clear when I announced my appearance on day one of the hearing.
Right, thank you very much. I think that clarifies matters. Yes, Ms Eastman.
Commissioners and Chair, you'll remember that when I opened on Monday morning, I said that the first part of the hearing would address the case studies and the experiences of Mitchell and Daniel Rogers. And I indicated that later in the week that we would turn to the response to Anne-Marie Smith's death. So we've now reached that stage of the proceeding where we're going to turn to the various reports that have been published following investigations in relation to Anne-Marie Smith's death, and more specifically the response of relevant agencies. Dr Bennett here in Adelaide will shortly give you an opening in relation to an overview of the various reports that the Royal Commission will address, and then you'll hear from Anne Gale. But we wanted to start in terms of reflecting on what lessons we can learn from what was described as the appalling death of Anne-Marie Smith, by starting with the observations of one of Miss Smith's friends. Commissioners, you'll find in the hearing bundles, in Part A behind tab 55, a statement of Brooke. Brooke made the statement on the 26th of May this year, and she has affirmed that the contents of the statement are true and correct. I'm going to read to you Brooke's statement. She didn't feel able to come and speak to you in person about it.
Yes, please go ahead.
I first met Annie when I started primary school. She was 7 years old and I was 9. I think Annie had recently started at our school, as Annie's parents wanted her to attend a mainstream school after spending some time in a school for children with special needs. I remember she had a blue walker and was relatively mobile at that stage. I don't think she ever used a wheelchair at school. I guess like many kids, I noticed that Annie had a disability, but I never asked, and Annie never told me about it. To be honest, it was only at Annie's funeral that I learnt she had cerebral palsy, and we'd been friends for over 40 years. I'll pause there, and Commissioners will see that Brooke has also provided some photographs, and those photographs will be displayed while I'm reading this statement. Brooke says this: "Our teacher asked me to help Annie, so I sat next to her in class and would go with her to the toilet in case she needed assistance. The school installed ramps and handrails throughout the school and an accessible toilet. During recess and lunch, I would often sit with her as she didn't go into the playground with the other children. I think that was partly because she couldn't do some of the physical activities that the other kids could. But in hindsight, I think she held back from being more involved. We would sit in the corridor that ran alongside the classrooms, talking and playing various hand clap games. I remember Annie's mum would always pack barbecue shapes and Monte Carlo biscuits in her lunchbox. Annie never ate them, so I was more than happy to oblige. Annie was the first child at our school with a disability, though a few years later, a boy who used forearm crutches also started at the school. I don't remember other children picking on Annie, but I'm not really sure how she felt about school or the other kids around us. I guess it was the days where there wasn't a more open conversation about disability and inclusion. I would regularly go to Annie's house on the weekends during primary school. I remember Annie had a very close relationship with her parents, and I think they were very protective of her. She was particularly close with her mum, and they spent a lot of time together. They had a pool, and I was often keen to have a swim, but Annie wasn't interested, and therefore we would stay inside. Annie liked music and was particularly fond of ABBA. I remember that she would get up and jig along whenever an ABBA song came on, and she was always dressed in nice clothes, and she used to get her hair done in a salon when Mrs. Smith was alive. As an adult, Annie also loved happy plants, and I gave her these for birthdays or Christmas on several occasions. She often had vases of lilies around her house. Annie repeated a couple of years of primary school and was on a special learning program. But as there was a 2-year age gap between us, Annie would jokingly call me a baby and I'd call her an old lady. I went off to high school a year or two before Annie. We attended different high schools, but I know Annie had at least one good friend at high school in Adelaide, and she kept in contact with him throughout her life. We saw less of each other during high school, as I played a lot of sport on the weekend, and Annie rarely left her parents' home. When I think about it, during our friendship, and even into adulthood, she never came to my house, and we never caught up in a cafe or restaurant, and I always went to her home. During secondary school, Annie and her family moved to Melbourne for about 3 years. We stayed in contact, talking on the phone regularly, and when I was about 15 or 16, I caught the bus over to Melbourne with another friend, and we stayed with the Smiths for 2 or 3 nights. I remember we were really excited to visit the CBD, but Annie didn't want to come and opted to stay at home. As a teenager, I wanted to get out and explore the new, exciting city. I think Annie finished high school in Melbourne, and then the family moved back to Adelaide. After school, I started working full-time. I was studying at TAFE. I also had a boyfriend, so I didn't have much spare time, but I continued to catch up with Annie when I could. As far as I am aware, after Annie finished school, she did not work, study, volunteer, or do any other regular activity in the community. Annie had her 21st birthday at her nana's home in the Barossa. Her nana was also a very special person in her life. A small group of close family and friends attended, but I remember this was a difficult period for Annie. A close friend from school and his stepdad were tragically killed when struck by a car whilst they were crossing the road a few weeks before her birthday. She had spoken to me many times about having a crush on this particular guy, and I know she was quite devastated by his death. Annie came to my engagement party, wedding, and also visited me in hospital when my son was born. I continued to drop around to see her with my children. Annie was good with them and would always talk to them and ask questions. My marriage ended when my children turned school age, so I would usually visit her when they were with their dad, as it was easier. In 1990, I moved almost 1 hour away from Annie's house, so whilst I didn't see her in person as often, we regularly spoke over the phone or texted. Annie was heartbroken when her mum died of cancer. Aside from the emotional distress, this also led to changes in Annie's day-to-day life, and she started to receive more in-home care. 3 months later, her father also passed away suddenly, and Annie said he died of a broken heart. I think he had a heart attack. Annie always loved her dogs. I remember she had dogs when she moved back from Melbourne, and they lived with her in the family home. Her last 2 dogs, Dina and Maggie, were important companions, and Annie was also very sad when they passed away a few years before her death. I know it was her plan to get a new puppy. In January 2018, I moved with my partner to a neighbouring suburb, only about 15 minutes away from Annie's home. We were both working full-time with stressful jobs, and I also had foot surgery in July that year, which meant I couldn't drive for 3 months. I didn't have a lot of time. However, I noticed that around this time, Annie also started to change as a person and became quite negative. Despite living much closer, I stopped visiting her. We had a falling out approximately 1 year before her death, so we didn't speak during the final year of her life. This is something I really struggle with. I shouldn't have made excuses. I carry a lot of guilt about that, and I know that things would have been different if I had gone around to see her. For me, it is still incomprehensible what has happened to her. Annie could be headstrong and stubborn. I would try to help her by making suggestions about how she might deal with a particular issue or problem, but she was always adamant that she would do it her way. I wish that Annie had involved herself more in the lives of her friends and community by rarely leaving the house and not pursuing interests, hobbies or work. The possibilities for her life and her connections with people were very restricted. I feel that she may have had a much fuller life if she'd been more strongly encouraged to get out into the community at a younger age. I feel privileged to have been part of Mr. and Mrs. Smith's family. They always made me and my family feel welcome. Annie was a caring person who was given a lot of love by her family. We watched each other grow from little girls to adult women, and I will always cherish our friendship through many good years. One thing I will never forget about Annie is her laugh. Sometimes she would start laughing for no apparent reason. I may have tripped or done something silly, and off she would go. I would have to remind her to breathe. I remember one day saying goodbye and leaving the house while Annie was laughing about something. I could still hear her laughing as I reached my car parked outside in the street. Annie, you are loved, you are missed. Rest in peace.
Yes, thank you, Ms Eastman.
Thank you, Commissioner.
Yes, Dr Bennett.
Thank you, Chair. I will do a brief opening now in relation to the two reports and following on from the earlier addresses on Monday. On Monday morning, in their opening addresses, the Chair of this Royal Commission and Senior Counsel assisting spoke of the death of Miss Anne-Marie Smith on April 6 of last year and briefly referred to what have been described as a substantial period of neglect, Miss Smith having lived in squalid and appalling circumstances. Miss Smith had been an NDIS participant, lived by herself in her own home, and had a single carer employed by a registered service provider. Also referred to by both the Chair and Senior Counsel assisting were the constraints of this Royal Commission in undertaking any inquiry in relation to deaths, such as that of Miss Smith, with the Chair citing the Royal Commission's terms of reference, which relevantly referred to, and I quote, the need to ensure that evidence may be received by the Royal Commission that identifies particular individuals as having been subject to violence, abuse, neglect or exploitation is dealt with in a way that does not prejudice current, future criminal or civil proceedings other contemporaneous inquiries. Having regard to these terms of reference, and given that a number of other investigations and inquiries are underway, including criminal proceedings, this part of the hearing will be directing attention primarily at the measures taken in response to investigations that have already been conducted and concluded and are publicly available. In particular, this part of the hearing will consider the responses of the DHS, the NDIA and the NDIS Commission to findings and recommendations of two reports. Those responses and those reports are those of the Honourable Alan Robertson SC, entitled Independent Review of the Adequacy of the Regulation of the Supports Provided to Ms Anne-Marie Smith, an NDIS participant. That report was presented on the 31st of August 2020 and will be referred to as the Robertson Report. The other set of reports are the interim and final reports of the South Australian Safeguarding Task Force that were delivered respectively on 5 June and 31 July 2020. There was also a supplementary report from the task force that was presented on the 28th of September 2020. This supplementary report is a compilation of the final report together with some supplementary material. It is this latter report that will be referred to as the safeguarding report in this hearing. The findings and recommendations made in the two reports will be the subject of this part of the hearing. More specifically, the two reports will raise a number of issues for consideration and they both make associated recommendations. And it is from these issues raised and the recommendations made that three key issues and various subcomponents have been distilled to be addressed in this part of the hearing. Other associated issues may also be addressed as they arise. Senior Counsel assisting in her opening address has already described the triggers for the establishment of the inquiries that resulted in the two reports. She has also described the context in which each of the inquiries took place and the respective methodologies adopted. It therefore only remains to set out the key and associated issues that will be the subject of inquiry over the next couple of days. The first of the key issues is the identification of circumstances of heightened risk of neglect or abuse that a person with disability might find themselves in. The Royal Commission will hear evidence from witnesses as to the evolving understanding of risk and the processes to identify risk. This will include consideration of the effect of being isolated from the community and/or the absence of friends and family. As part of this, evidence as to the potential processes by which any identification of risk ought to be assessed will be heard. The second key issue relates to the consideration of what is the appropriate response or safeguarding once any heightened risk of abuse or neglect have been identified. Now, in this, findings and recommendations in the safeguarding report and the Robertson report considered a number of responses, including whether for NDIS participants identified at being of heightened risk, whether there should be a specific person with overall responsibility for that person's safety and well-being, whether participants should be supported to access regular health checks, whether planning and reviews of participant plans ought to take place face-to-face, whether steps to connect with the community and other informal and natural safeguards should be prioritised, whether participants living alone in their own home should have a sole carer, whether there is a conflict of interest, whether the provider of support coordination is also the same provider that provides core supports, whether all participants at risk should have access to a community visitor scheme. Now, in relation to the community visitor scheme, Ms Boswell for South Australia will give evidence of the current position of the community visitor scheme in that state. The third key issue relates to information sharing between the State of South Australia, the NDIA and the NDIS Commission. In conducting this inquiry into those key issues, the Royal Commission will hear from 5 witnesses. Of these 5, the evidence of Mr Bruggeman on Monday has already touched on a number of the issues. Later this morning, the Royal Commission will hear from Ms Anne Gale. Ms Gale is a South Australian public advocate and acting principal community visitor. She was also a member of the Safeguarding Task Force and made submissions to the Robertson report. Following this, and as already anticipated in the openings on Monday, the Royal Commission will then hear from Mr Martin Hoffman, CEO of the NDIA, then Mr Graham Head, Commissioner of the NDIS Commission, and Ms Lois Boswell, Chief Executive of the Department of Human Services, referred to as DHS, South Australia. Ms Boswell was also a member of the Safeguarding Task Force and made submissions to the Robertson report. And Commissioners and Chair, the first witness will be Ms Gale.
Yes, thank you very much. Do we have Ms Gale on screen?
Yes.
Good morning, Ms Gale.
Good morning, Chair.
Thank you very much for coming to the Commission to give evidence today. If you would be good enough, please, to follow the instructions of the Associate who is in the room with you, she will administer the affirmation.
I will read you the affirmation. At the end, please say yes or I do. Do you solemnly and sincerely declare and affirm that the evidence which you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Ms Gale. I'm sure you're aware, but just to be clear, there are 2 commissioners in the room with you, Commissioner Bennett and Commissioner McEwen. Dr Bennett, who will be asking you some questions, is also in the Adelaide hearing room. I am located in Sydney, so you will see me mystically on a screen. Now Dr Bennett will ask you some questions.
Thank you. Ms Gale, can you tell the Royal Commission your full name?
My full name is Annette K. Gale.
And you've provided the Royal Commission with a statement dated the 28th of May 2021?
Yes.
Right. And have you read a copy of that statement recently?
Yes.
And have you got any corrections or amendments to make to that statement?
There is a correction. The statement refers to my current roles as Public Advocate and Acting Principal Community Visitor. On the 3rd of June 2021, I was appointed Principal Community Visitor.
Okay. So, Ms Gale, then looking at paragraph 3 of your statement, would it reflect accurately the position if it read, I am currently the South Australian Public Advocate, appointed in December 2015 and appointed Acting Principal Community Visitor in September 2019. And then an additional sentence added, on 3 June 2021, I was appointed Principal Community Visitor, brackets, no longer acting.
That would be correct.
Thank you. Okay. Other than that amendment, is that statement true and correct?
Yes.
Thank you. And Commissioners, that statement is in hearing bundle A at tab 61.
Thank you.
Thank you. Ms Gale, in addition to the current positions you hold, at paragraph 4, you've set out some of the positions you've held in the past. Now, they've included, you've said there that you were the Commissioner for Equal Opportunity, Deputy Commissioner, Consumer and Business Services, Deputy Chief Executive, South Australia Department for Families and Communities. And you've said you've also held leadership roles in ageing, disability and housing. Over what period were those roles undertaken?
My first executive role would have been in housing in about 1999. So from there, as an executive, the maths would probably be over 20 years.
Thank you. Okay. You've also said there that you're a member of a not-for-profit board, Access to Place, that provides community housing for people living with disability. How long have you had that appointment?
I believe I would be into my 3rd term and coming up to 6 years.
Thank you. And of course, in May 2020, following the death of Anne-Marie Smith, you were appointed as part of the South Australian Task Force.
Yes.
So bringing you up to the current, your current role as the Public Advocate, could you explain to the Commissioners what that role is?
The Public Advocate is a statutory officer appointed by the Governor and is accountable to the Parliament of South Australia. The role focuses on speaking for and with people who are deemed to have, the legislation talks about mental incapacity. The role also can be appointed as a guardian of last resort for adults with a mental incapacity by the South Australian Civil and Administrative Tribunal. The role also includes broader functions where I can speak about unmet need and report to ministers about unmet need for people with mental incapacity and their families and carers. That's a bit of a summary, but the functions of my role are outlined in my statement.
Thank you. And just in terms of the role of the Public Advocate, that is distinct from the role, for example, of a financial manager. Where does your role start and the role of somebody who looks after somebody's finances begin?
The Public Trustee is another statutory officer that can manage people's finances.
Right, thank you. Now, from paragraph 10 on your statement, you've said the clients of the OPA are some of the most vulnerable, complex and marginalised adults with cognitive impairment in the state. And then at paragraph 12, you've said, as of February 2021, approximately 900 OPA clients were known to the NDIS and nearly all had approved plans. And then you say work continues to ensure the OPA clients who are eligible are engaged with the NDIS. So how is it that the OPA ensures that process happens?
So when we are appointed as a person's guardian, when the public advocate is appointed, we will assess whether they may have needs and a disability and pursue an access request. Very often a person may already be a participant in the scheme. So we may be appointed when someone is a participant, and if not, we might seek access to the scheme.
Okay.
Who are your clients who are not eligible for the NDIS?
I think I caught your question correctly, that who are the clients who are not participants, is that right? Yes, I can be appointed for any South Australian adult, so I might have a range of older people, people over 65, they may be recipients of my aged care services, for example, they may be living in the community. Then there may be other people who are mental health patients who have not been deemed to have a psychosocial disability. So I can be a guardian for a range of adults.
Thank you.
Okay. Over the page from paragraph 14, you've set out the role of the community visitor scheme, and you've said the CVS or community visitor scheme is comprised of the principal community visitor and appointed community visitors. So can you explain that role to the commissioners?
So the principal community visitor role is also a statutory officer that is appointed by the Governor and works in South Australia to two ministers, the Minister for Health in relation to mental health services, and secondly to the Minister for Human Services for people who are residing in state-run disability accommodation services. So the principal community visitor is a paid officer. The other who can conduct visits, and we work with volunteers to carry out the majority of other visits. So they are a volunteer, trained, skilled, a volunteer workforce that we work with to undertake those visits.
Mm-hmm. Right. And from paragraph 20 of your statement, you've set out the current scope of the community visitor scheme here in South Australia. You refer to a period before May 2019 and the position then, and you've given some evidence that it changed after May 2019. So can you please explain those two different scopes to the commissioners?
So prior to May 2019, the scope of the scheme was such that it could visit the mental health services that I've mentioned, and there hasn't been change in mental health services visitations. The change relates to disability services, where we visited state-run funded services as well as state-funded non-government services. That a couple of years after that commenced, which I think was around 2013, the scheme expanded to also visit supported residential facilities and day options programs. So the scope was quite inclusive of all of that up until May 2019. And following that, the scope was refined to visit state-run disability accommodation only because of the establishment of the NDIS Quality Safeguards Commission and their regulatory responsibilities for safeguarding.
Mm-hmm. And what did that change of scope mean for your clients?
Do you mean public advocate clients?
Yes, sorry, the public advocate clients.
Yes. Well, in September 2019, the state government decided that the CVS scheme could also be extended to visit clients who were NDIS participants who were under the guardianship of the public advocate. So that gave a broadening of the scope to work with the public advocate to also visit participants, NDIS participants, and they might have been living in a range of accommodation services.
Right. And is that the delegation you've referred to there at paragraph 28?
That is the delegation, yes.
Okay. And from your perspective, what benefits did you see then and do you see now in relation to that capacity having been opened up due to the delegation?
There are many benefits of being able to work with community visitors to visit clients of the public advocate. We might be, as a community visitor, visiting a state-run service, either in a mental health facility where someone might have a psychosocial disability or a state-run disability home. So those people may also be clients of the public advocate. So there is some complementary work that can occur there, and reports can be provided back to the public advocate about those clients. Both of the roles have responsibilities for addressing and reporting on unmet need and systemic issues. So again, they are complementary functions of the two roles.
Okay. So on that issue, Ms Gale, if you go to your paragraph 30 there, you've said that this arrangement does not replace the visits by the OPA staff, but provides additional scope for the CVS to assist the public advocate. Now, just can you say a little bit more about the distinct, the two roles there? And when you explain the role of the OPA staff member, is that somebody, is that the same person that visits the client over time?
So, my staff who operate under delegations from myself as the public advocate are substitute decision makers, and their role, we do aim to visit clients as a minimum of once a year, but more often than that, depending on the needs and circumstances of the client. So we make decisions, so having that complementary visitation element of the CVS is of great assistance to our office. Have I answered your question?
I mean, in terms of the role of the staff member, does responsibility for a particular participant attach to a particular staff member? Or could it be each year or each 6 months a different person attends?
The way we work in our office is clients that we might call needing active decisions will be allocated to a dedicated staff member, and that staff member may visit that person on a monthly basis depending on what's required, or 3 monthly depending on the circumstances. Where clients who are not requiring active decisions, we tend to monitor them through a team approach, and we have a schedule of visiting for those clients.
Thank you.
Can I make sure I understand something? I think you said that as of September 2019, there was a change, so the community visitors were replaced by the NDIS Commission as far as visits to NDIS participants are concerned. Was my understanding correct?
Perhaps I can clarify. In September 2019, the public advocate delegated to the principal community visitor to conduct visits to NDIS participants who are under the guardianship of the public advocate. By reference...
So they are acting in the capacity as delegates of the public guardian. They're not acting in the capacity as community visitors.
I delegate those responsibilities to those community visitors. Technically at law, I'd need to check your point, but they are deemed to be community visitors carrying out those delegations of the public advocate.
My understanding of what happened is that there was legal advice given that following the establishment of the NDIS Commission and its regulatory powers, there was no room for the community visitors to exercise any powers of compulsion as far as entering into accommodation that NDIS participants were living in. Is that your understanding?
That is my understanding.
All right. We'll work out the legal position later on, I think.
Right. From paragraph 31, Ms Gale, you talk about accommodation services and those issues as they relate to the OPA clients. You've said there at paragraph 31, I'm particularly concerned for OPA clients with disability who face heightened risks of violence, abuse, neglect and exploitation because they cannot access appropriate accommodation in a timely way. Can you explain to the Royal Commission the nature of that problem?
At times, when people are under the guardianship of the public advocate, they are often people with very complex needs, sometimes complex behaviours, communication skills are complex, and they can be, dealing with, I guess, potential risks on a daily basis. When we have difficulty locating appropriate housing for those people, sometimes people are, the service providers have difficulty providing the right level of supports for people, and sometimes the service provider reports to us they can no longer work with that person, and we are often left with facing a social admission to hospital when people are experiencing difficulty with their support provider and their housing provider.
Right, and when you say in a timely way, it takes some time for you to work through that and find accommodation.
Yes, there are a range of processes. If I talk about the NDIA planning process, for example, there's a range of processes that have to be worked through. A person has to have a goal for their accommodation in their plan. Then there has to be a housing assessment undertaken, followed by other assessments like occupational therapy, how well someone can live in the home, what supports they need. Then we need to engage a support coordinator to locate housing. And so these can be lengthy processes. And then approvals, if need to go through, the NDIA, and if SDA is specialist disability accommodation, if the person seeks to have eligibility for that, then that's another process that's approved by a panel in the SDA. So we experience months for those processes to take place. So if someone is waiting to be discharged from hospital, that can be a lengthy process, for example.
Right, and is it the OPA that is working together with whoever is coordinating that issue in the NDIS?
We rely a lot on the specialist or support coordinator. So if I'm referring to support coordination, I'm generally inclusive of specialist support coordination because that's something that most of our clients require. At the planning stage, the specialist support coordinator is not engaged in the process. So we actively seek that and work with the planner to seek out the housing. Then we seek a request for exploring housing options, which is now called a request for home and living supports assessment. And that process can take its course, and we seek out a specialist support coordinator as well and rely on them to do the legwork to progress all of those assessments, because I come back to our role as decision makers and we need that specialist support coordination to drive a lot of that work.
Thank you. Now, at paragraph 35, you say that the NDIA provides funding for specialist disability accommodation, but it's expected that only 6% of participants with the NDIS will be eligible for this. Now, what happens to the clients from the OPA that are not eligible?
So that means that they don't necessarily get that additional funding for that high level of support or modifications. And in some cases, people don't need that, but they still may have challenging behaviours, and they might need to, have housing that's located in an appropriate location with the appropriate supports. So that 6% is a very small number, and so therefore, there are many other people with other housing need.
Right, okay. At paragraph 36, you referred to the former state government system where there was a centralised approach to filling supported accommodation vacancies across the government and the non-government sectors. How did that system work then, and how is it different now?
So that was a service, as you say, run by Disability SA. It was an after-hours service. It would have a register of properties that could be utilised for what you might call short-term or respite accommodation, and then out of business hours, you would absolutely minimise hospitalisation. That doesn't exist now, and so we are seeing a change in the landscape, and that's understandable with the reform, but as a result there are some issues around finding short-term accommodation, particularly after hours.
Right. Now, on the next page at paragraph 38, and that's still on the accommodation issue, and I think you've touched on this already. You've said that the OPA staff are reliant upon the support coordinators and the specialist support coordinators, and you've set out a number of the factors that they're dependent upon them for. In this process, what will be the role of the OPA staff member if the support group are doing that?
A decision maker. So once the support coordinators come back with some possible options for accommodation, then my staff will consider those if there's more than one, which often there isn't, and will make a decision whether that's appropriate accommodation. May request for some further research to be undertaken if it's not deemed to be appropriate.
Right.
So that's in accordance with the powers of a guardian.
Okay. You also on that same page refer to the need for a provider of last resort. As part of this, you've also raised the issue of clients with complex needs that have services withdrawn. So in terms of that issue of a need for a provider of last resort, can you explain that dilemma to the commissioners?
With the reforms that have taken place, we have seen a rapid expansion of service providers in the market, and that's encouraged and acknowledged and been a goal. Sometimes the knowledge of those, and sometimes even the skill of support providers might vary, and for clients with particularly highly specialised supports, and often if you have a public advocate in your life, you might have particular needs and do have particular complex needs at times. We're finding that service providers come willingly to support a client, but over some time that their workforce is struggling to support the client, that perhaps the challenging behaviours that the client might have, and they withdraw their services. And so we do have experiences of where service providers say we've exhausted all our options, all our staffing, and we're no longer able to provide support for this person. Where that is, person's accommodation is also with that SIL provider, that's a particularly challenging issue because the housing and the support provision can be at risk.
That's right, and you give. I'll bring you to your evidence on that a little bit later. At paragraphs 41 and 42, you've again going to the issue of the specialist support coordinator services, and you've said that they're sometimes or always not well versed in locating housing. At paragraph 41, and then at 42, you're bringing it up to what's currently happening. You've said in South Australia, the DHS and NDIA have been exploring ideas for increasing and educating specialist support coordinators in the various housing opportunities. Where is that at the moment?
And I'm part of that work and working, I guess, at a systemic level to try and develop some forums for education for specialist support coordinators. We do have a housing hub in South Australia. We're not sure how well support coordinators know about that and whether all housing providers are using it. We know some are. So we think there's an opportunity to show some leadership and connect people. It is a market-based system and we recognise that, but for high and complex needs, housing is the top of, one of our critical issues. So providing, I guess, a helping hand to bring people together to understand how we can better access housing in this state. People are willing to work together, which I'm very encouraged by. The South Australian Housing Authority established a single housing register in March of 2021 this year. So that's in its early days, but again, a promising indicator of us trying to work together to, increase, I guess, streamline the processes, and we need our colleagues in the NDIA to be part of that as well going forward. So they're encouraging signs.
Right. Now, is the issue of the housing provider of last resort part of that discussion?
I think it has been part of the discussion, but I think the group initially will focus on the location of housing.
Right.
I think the issue of the housing connection with support, I probably will address through some other advocacy means.
Okay.
We heard in public hearing 13, which was the last hearing that we held, the enormous difficulties that can arise if an accommodation provider, and more so if the accommodation provider is also a provider of services, decides to terminate an arrangement of providing accommodation for someone who has extremely complex and sometimes challenging needs. You've referred to the market-based system. As far as you're aware, and I assume your knowledge is limited to South Australia relevantly, are there constraints upon a accommodation provider in this market-based system for terminating the residential entitlements of someone with complex needs who is living in supported accommodation?
The tenancy arrangements should be compliant with the Residential Tenancy Act of the relevant jurisdiction, so they are jurisdiction-based. Some of those...
Sorry, are you suggesting that a person with disability in supported residential accommodation through a registered NDIS provider is entitled to the protection of the South Australian Residential Tenancies Act?
If they're renting in the private market, yes, there should.
No, we're not talking about... Oh, I see. You're regarding someone as receiving accommodation through supported by the NDIS as someone in the private residential market.
Yes, in this context where, for example, a SIL provider has rented a property in the private rental market. And they may put themselves on the tenancy agreement along with, maybe with or without the resident.
So your experience is it, that the State Residential Tenancy Act does apply in these situations?
We are looking at these agreements. They are fairly new that are coming my way. And we think that in some cases they do need to comply where it's rented in the private rental market with the Residential Tenancies Act. Some of them may be a boarding house, equivalent to a boarding house arrangement. So it's a piece of work that is unresolved and needs to be actively pursued. And it is something that I'm raising with my colleagues, both here in South Australia and with the Quality Safeguarding Commission. And I have written to Mr Hoffman and Mr Head on this issue in recent times.
This may raise some legal issues not dissimilar to those that arise with community visitors exercising powers of compulsion in relation to supported residential accommodation. But again, we'll come to those at some stage in the future. Yes, Dr Bennett.
Just adding, it's Commissioner Bennett here, just adding to the Chair's question. In para 23 of your statement, you talk about a conflict of interest where the SIL provider and the housing provider are the same body, and you mentioned that they are probably not giving them tenants' rights and standards expected that under a tenancy arrangement.
Did you say 23?
63.
63. Yes, there is potentially, in my view, a conflict of interest where it is a joined-up housing and provider arrangement. And
can you explain, is that because you think that if they're also providing services and they may not like providing the services, then that person loses their home as well as some perception that they no longer want to be a service provider, they lose the home and the service at the same time?
Yes.
So there's no rights for them to stay in there as a tenant?
Well, their rights may be compromised, and it will depend on how well that provider has structured the support and the tenancy agreements. So sometimes I've seen agreements where they are rolled into one, sometimes with the support and housing, and we request that they must always be separated. And then some I have seen where the SIL provider is also on that tenancy agreement. So these issues are unresolved and raise concerns for us. Someone might need a maintenance request to be addressed, and if the SIL provider is also the landlord, then again, that might be an issue in terms of getting that maintenance issue pursued.
So is that suggesting in those situations where they both run the building and provide the service, there's probably really functionally very little tenancy rights for the person? Is that?
I think that's possible, absolutely. Mm-hmm. And they might not own the dwelling, they might be leasing it from the private rental market. So, on the one hand, we're seeing some creative responses, to the provision of housing, but they need some extra regulation, in my view, to make sure they do comply.
And is that most group homes in South Australia in that situation?
Not usually group homes. Most group homes, a lot of group homes are run by community housing providers in this state through some arrangements that the South Australian Housing Authority had established and leased properties to community housing providers. Some community housing providers own their own stock. So there is a clear separation where the community housing provider is the landlord and the SIL provider or support providers is a different organisation. It's occurring where people are primarily, a SIL provider is leasing or possibly owning, I couldn't discount that, but leased or owned in the private rental market, not from a community housing provider or the South Australian Housing Authority. So in those circumstances, a lot of the group homes for disability services, state-run disability services, are accommodated in community housing.
Thank you.
Right. You address that issue, Ms Gale, at paragraph 62, is that right? The issue of the SIL and the link to accommodation.
That's right.
Yeah. And just above that, paragraphs 59 to 61, you refer there to a letter you sent to Mr Hoffman dated the 15th of April, raising the issue of the potential conflict of interest. And then you've provided the Commission with a copy of the letter you sent to Mr Hoffman, and then a letter you received back from Mr Hoffman. And you've said at paragraph 61, Mr Hoffman has indicated his willingness to work together on the issues I've raised in my correspondence. On that issue, are there any outstanding issues in relation to that particular issue of conflict that are outstanding and need steps to be taken?
In relation to housing?
In relation to housing.
Yep. I think there's one other issue I would just flag that I would like to explore further, and particularly with the NDI. The NDIS and the NDIS Quality Safeguards Commission, is the issue of rents. So I think I refer to that in my statement, where I have had experience of the rent being high when we're being asked to approve a particular arrangement for someone, and when I've inquired about that, the response is the SIL provider will manage those costs within the whole package. So generally people in community housing or social housing would pay a 25% of their income in rent. So that's a guide that I would use. So when I look at some of the rents, I go, oh, is this high, is this not? Does it comply with that? And the response about whether or not that is an appropriate arrangement for the SIL provider to top up the rent is something that I think deserves inquiry.
Okay. You've also mentioned at paragraph 57, you've got concerns, this is the whole of life providers, you've got concerns when there's a single service provider in relation to an NDIS participant. What is the nature of your concerns there?
Where there is a single provider for the provision of independent living, SIL, and support coordination, there is a potential conflict of interest. This was debated in the Safeguarding Task Force. I acknowledge that there are differing views on this. But as good practice in my office, I seek out and ask my staff to look for a support coordinator who is different to the SIL provider. And that goes to the issue of having more than one player, more than one set of eyes in the person's life. And that also that role of support coordinator is a very important one for OPA clients, to ensure that there is someone else who's checking in, who is independent of that SIL coordinator.
And are there times when you find yourself in a position where there is a single service provider?
We may come across it, but generally we will seek out to separate that.
Now, at paragraph 65, again, still in relation to housing, you've said the OPA's position is that housing and support services should be separated so that when support services fail, other services will continue. Then you say the Independent Advisory Council, the IAC, to the NDIS, reported in November 2019 on challenges in housing and support. Now, before I take you to the quote you've given the Commission, Ms Gale, can you explain who the Independent Advisory Council to the NDIS is?
The Independent Advisory Council is a group of advocates and people with lived experience, some very reputable Australians who report to the NDIA board. Mm-hmm. It's established in the NDI Act, so it does have a formal role and a responsibility to report on strategic issues, I guess systemic issues for participants in the NDIS and its implementation.
Right. So, in relation to the quote which is on the next page, you've quoted that group as saying, the IAC has long argued for the importance of the separation of housing and support being critical to participant choice and control to ensure that residents dissatisfied with supports do not have to move homes. So, can you explain that quote in relation to the stance that the OPA has taken?
The quote supports our position, really, of separating that out. A home should be that. What supports come and go in that home should not be dependent. The housing tenure needs to be standalone, and I do think this quote goes to that issue. Very much so, and endorses that principle that has been a long-standing principle that in Australia, in the housing sector, they have worked toward that separation of housing and support provision.
Thank you. You've also given evidence in your statement about risk assessment and the identification of risks, and given evidence of that in relation to your clients. So, for example, on page 19, Ms Gale, if you go to paragraph 73, there's a heading there, a risk assessment needs to be undertaken during the NDIS access and planning process. And you've said there at paragraph 73 that that's the first point to identify and safeguard people with disability who may be vulnerable. So how do your clients fit in with what you've said there?
Our clients, it's vital for them at the access and planning process for their particular needs to become, I guess, a client of the public advocate. Public advocate is a guardian of last resort, and the person is deemed by the SACAT that I've referred to before to have, complex needs and impaired decision making. So it is critical that that process, the planning process and the access and planning process, identify and work through the particular needs and supports of the person, and safeguarding is part of that process. It should begin with the plan.
Right. And what kind of role then does the OPA take in that planning process? Do they take an active role even though they're just, well not just, but they're the substitute decision maker? My staff are encouraged wherever possible to attend the first planning meeting for the person. We advocate for the needs. Sometimes we may not have met the person before, so we might seek out someone else who knows the person well. But then it is important, so we might make decisions, but it's important from there on in to recognise that the implementation of the plan sits with support coordinators and other roles. The role of the Guardian is to approve and make decisions about, health, housing, access arrangements. Mm-hmm. Right. And from paragraph 77, you've just mentioned the role of the OPA in relation to safeguarding, but looking at the role of the NDIS and the NDIS Commission in relation to safeguarding. You've made some recommendations there, and you've said there that, the first one you've referred to being that safeguarding must be a focus at all stages of the NDIS process. And does that relate to what you've said at paragraph 73 there in relation to the access and planning process?
Yes, it does relate to that. The planning process is an opportunity to identify, then the implementation is an opportunity to ensure that, for example, there is not one sole provider involved, and there are a range of safeguards in implementing the plan.
Right. Now, you've set out a number of other recommendations, Ms Gale. I'm not going to take you to them all, but I will ask you to go to the bottom of page 20 there, and that's 77F. And you've said there, in terms of your recommendation, you recommend that those who support people with disability undertake training on supported decision-making to better enable them to support people with disability. Can you explain to the Commission what supporting decision-making is and distinguish that from, for example, substitute decision-making?
Okay. So substitute decision-maker in South Australia under the Guardianship Administration Act is about standing in someone's shoes, but it also does talk about understanding the person's past wishes, current wishes, and consulting them. So as a substitute decision maker, you might make a decision as if you were in the person's shoes. In practice, my staff are encouraged to undertake supported decision making. We currently have a grant working with SAMRI, the South Australian Medical Health Research Institute, to undertake supported decision making for clients under the Public Advocate to document their wishes going forth and to involve them in future decision making. So I believe we do it to a degree, but we do need to have training and understanding, and that goes to my point about, well, what is supported decision making? Lots of people agree with it as an important concept going forward to empower people with disabilities, even people with impaired decision making, particularly for people with impaired decision making, to be supported to make their own decisions, to recognise that capacity can fluctuate and that people can still make certain decisions. They might not be able to design a complex investment portfolio with their money, but they may be able to decide exactly what they want to spend their money on a daily, weekly basis. So we need to look at what this means. It is a process. It's a process of engagement to support people to make their own decisions, to remove bias, to remove influence. Supporters, to support a person to make their own decision, need to have skills and need to be trained. And it is an investment in time. It doesn't happen necessarily quickly. So I think I would encourage this. We talk about it, I think it's in NDIA rules, and our grant came from the NDIA IOC process. There's a recognition of the need for it. It needs to go into people's plans and needs to be funded and resourced for the reasons I've outlined.
Right. And when did your trial commence?
We commenced the project last year. We've designed our process. We've engaged a recognised person, Michelle Browning, to come and do training in our state. So we're halfway through the project, and we're about to embark on the process of engaging with our clients, or the training, and then engaging with our clients to commence this work.
Thank you. I'm just keeping an eye on the time, Chair, and I won't run over. Ms Gale, on paragraph 79, just above that, there's a heading that goes to the issue of a person with overall responsibility, specifically in relation to people who are at risk. At paragraph 79, you note that under the current arrangements, there are multiple contact points for NDIS participants, but no single person or role has overall responsibility for connecting the participant to paid supports and mainstream supports and being a single point of contact to assist them to navigate a range of systems. Now, you've said that there, and at paragraph 82, you've set out some of the consequences of that. Can you just give a brief summary about what you say of the difficulties or the pitfalls of not having a single person responsible?
Our experience is that as a specialist / support coordinator is the logical place to grow the connection and the one, the go-to person. Funding for support coordination in a plan is not necessarily ongoing. There is a view that a person can build their capacity, and that's supported in principle. One would support that. But for people with such complex needs, ongoing support coordination is required. It can't be capped. Sometimes the funds run out. Only yesterday, talking with staff about one of our clients, but the support coordinator won't pursue anything because there's no money in the plan. Therefore, we have to request a change of circumstances, and that can take 28 days if it's simple or 50 days if it's complex. So, that the money's run out for support coordination doesn't work for clients under the guardianship of the public advocate. It needs to be ongoing. And then the role needs to grow to be that go-to person. Because when the crisis happens, and if there's no money in the funds, and I had it yesterday, the person ends up in hospital. Right. And it's not appropriate necessarily.
And what percentage of OPA clients have a support coordinator?
We always ask for it. I don't have the specific percentage, but it would be very high. Very high.
Most clients?
Most clients.
Right. Now, you've already touched on this, but what percentage of those clients are going to have ongoing needs in relation to support coordination?
All of them would have ongoing needs, in my view. There might be the exception, but most of them, majority by far.
So in relation to how this might happen in a plan, what sort of accommodation is made to that likelihood in relation to whether there's ongoing support coordination funded as opposed to short term?
If I've understood your question, I think in the plan, the support coordination funding needs to be, not capped, and it needs to be flexible. So the plan needs to, when we do have the person in crisis or the service provider has not got staff that evening available, that the support coordinator the funds can be ramped up to enable them to seek out other supports, and also that somehow that person can be engaged in some after-hours work.
Right. On that issue then of that support care worker, at 82B there on that same page, you've referred to a lack of consistent, trusted person in the life of a person with disability has put pressure on the OPA staff to fill that gap by undertaking tasks that fall outside of their traditional remit. Turning to the first part of that sentence, referring to a trusted person, how, in your view, does that trust relationship become established?
It needs to be, that independent relationship as well. As I talked about, say a support coordinator, we engage them independent from other services. They need to be available. They need to get to know the person, be involved in the process at the beginning. Our preference will be that service coordinators are involved in the planning phase. They're not. They come in later. And that they get to understand the person's needs. It goes to safeguarding. They get to understand any risks that might be involved and know the client well and independently. That's an ideal scenario.
Right. And you as the substitute decision maker there, therefore are the one exercising choice and control about the particular support coordinator that is chosen.
Yes, we will make a decision about a support coordinator and work with that support coordinator as far as possible. We're not, Guardians, the OPA, we are not a service provider. We need that go-to person to work with, to keep the plan ticking over, making sure everything's in place, making sure the person's, getting the service that we've approved.
Yeah. Okay. And you've also just raised the issue that you've dealt with on the following page about your wish list, if you like, that it would be good if the support coordinator was brought in early in terms of the planning process. Have you seen that happen, or is that something that's been suggested or trialled, or Where is that idea currently standing?
I think it's still at a concept idea stage, where because the process of engagement through the NDIA plan is still such that, you know, a decision is made about a support coordinator, doesn't come into the planning process. That'll be something we'd encourage, you know, for future consideration.
Yes, thank you. Towards the end of your statement, and I won't take you through it, but you have set out some of the information sharing strategies that you're aware of. But I will take you to your paragraph 102, Ms Gale. And there you say the OPA is waiting the formalisation of a head memorandum of understanding of information sharing between the National Disability Insurance Scheme and the South Australian state government agencies. Can you, first of all, can you update the Commission on where this is up to? And then secondly, let the Commission know any likely consequences or impact you think that might have.
The lead for the Memorandum of Understanding, I believe, sits with the Department for Human Services. All government agencies have been consulted, so I guess it's been a process of engagement with others like Department of Child Protection where there are children. So there's been a range of agencies. We've put forward our request for data sharing, and I believe it is almost complete. I believe it's imminent. And then that exchange of data between us and the NDIA about our clients and their funding arrangements will be able to flow more readily.
Right, and that's the benefit you find, when this comes into effect, that's the benefit.
Absolutely, like knowing what should be in a person's plan and what they're funded for and having that in one source. You know, that my computer systems were not designed. They were designed, before the NDIA came into place. So if I want to know who's got a plan and what's in their plan, I can't get it from the existing computer systems. This is a really rich source of information for us to understand what's in the plan and to work with the NDIA, have all of that sort of information to have more direct access about our client's plan.
Thank you, Ms Gale. Chair, they were the parts of Ms Gale's statement I proposed to take her to, and it's...
Thank you very much. Ms Gale, I'll just ask the Commissioners if they have any questions, and then I'll ask Mr Simpson if he has any further questions for you. So first I'll ask Commissioner McEwen, do you have any questions of Ms Gale?
No, thank you, Chair.
And Commissioner Bennett.
Just very quickly, the Community Visitors Scheme, how many community visitors do you have working, and how many people are people with disability that are community visitors?
We have 28 community visitors at the moment.
Sorry, 20?
28?
Yes.
We have lost some community visitors, and the process of recruitment during COVID was restricted. So it's been difficult to grow our numbers, and we currently have 9 in training. So I'm very pleased that we will be up to sort of 36 soon. 37, I hope. So we are a continual process of recruitment, which we are now reinvigorating post-COVID. And I don't have statistics, and I can look at that of who has lived experience of disability. I'm sorry.
If you could come back to me. And just the last quick question, because we've looked at other community visitors, some states pay for community visitors. Do you think that would attract more people to volunteer, or a broader array of people if there was some payment involved?
Look, the volunteers we have are fantastic in that they, do volunteer their time. I'm sure payment would be an incentive for some. I know other states pay on a casual basis. There's a variety of arrangements in place, so it may attract an additional pool of people.
Okay, thank you.
Thank you. I'll just inquire of Mr Simpson as to whether he wishes to make an application to ask you any questions.
No, Chair, no questions. Thank you.
Thank you. I take it no other legal representatives have questions they wish to put. In that case, Ms Gale, thank you very much indeed for both your very detailed and helpful statement and the thoughts that you have provided for how the various systems that interact might be improved. We very much appreciate your coming to the Commission today to give evidence. So thank you very much.
Thank you.
Dr Bennett, do we now adjourn?
We now adjourn for the lunch adjournment, Chair.
All right. We'll resume then at 1:35 Adelaide time, which will give us, according to my calculations, 1 hour.
Thank you.
The Royal
Thank you.
Commission is adjourned. The Royal Commission is resumed.
Yes, Ms Eastman.
Now, Commissioners, for the third time, I'm going to ask you to receive a document by way of tender, contrary to what I've been saying at the beginning, that everything will wait to the end. But before I start with Mr Hoffman, who's in the witness box now, could I tender the statement of Brooke, dated the 26th of May 2021, and the statement is behind tab 55 in hearing bundle A. And Commissioners, could you mark the statement Exhibit 14.4?
Yes, that statement can be admitted into evidence with the marking of Exhibit 14.4. Thank you very much.
So we now move to Martin Hoffman, and we just need to take his oath or affirmation.
Thank you very much, Mr Hoffman. Thank you for returning to the Royal Commission on another occasion. If you would be good enough to follow the instructions of the associate who is in the same room as you are, she will administer the oath to you. Thank you.
I will read you the oath. At the end, please say yes or I do. Do you swear by Almighty God that the evidence which you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much, Mr Hoffman. And just to explain where people are, you're in the same room as Commissioners McEwen and Bennett. Ms Eastman, who will be asking you some questions, is also in the Adelaide hearing room. I'm joining the hearing from Sydney. So Ms Eastman will now ask you some questions.
Thank you. You are Martin Hoffman.
Yes.
And you're currently the Chief Executive Officer of the National Disability Insurance Agency.
Yes, that's right.
I'll call it the NDIA for convenience. And you have provided a statement to the Royal Commission for this public hearing dated the 20th of May.
Yes.
You've got a copy with you.
I do.
And you've made some amendments to paragraph 101 of the statement and provided a corrigendum for the Royal Commissioners. Is that
Yes.
right? So together with the statement and the matters identified in the document provided today, are the contents of your statement true?
Yes, they are.
Now, have you been following the Royal Commission proceedings over the course of this week?
Somewhat.
Right. Well, if I ask you a question about something that has occurred during the course of this week and you're not aware of that, please let me know. Now, you have provided evidence to the Royal Commission in a written format before, and I think we were going to take some evidence from you at public hearing 5, but we didn't quite manage that. But Exhibit 5.45, Commissioners, contains Mr Hoffman's background. So, Mr Hoffman, you have held the role of the CEO of the NDIA since the 4th of November 2019.
That's right.
And you've been a public servant since 2009, first joining the Department of Prime Minister and Cabinet.
Sorry, yes.
And you've held a number of senior positions in the public sector, which have included Deputy Secretary of the Commonwealth Department of Industry and Science, Secretary of the New South Wales Department of Finance Services and Innovation, and Leader Services Australia Task Force for Minister Stuart Robert. Is that right?
Yes.
And you hold a Masters of Business Administration with honours from the Institute for Management and Development in Lausanne.
Yes.
And a Master of Applied Finance from Macquarie University
Yes.
and a Bachelor of Economics from the University of Sydney.
Yes.
You are a National Fellow of the Institute of Public Administration of Australia.
Yes.
As the CEO of the NDIA, your role is set out in the NDIS legislation, is that right?
Yes, it is.
And Section 159 sets out the functions of the CEO to say that the CEO is responsible for the day-to-day administration of the agency. The CEO has power to do all things necessary or convenient to be done for or in connection with the performance of your duties. And the CEO is to act in accordance with the objectives, strategies and policies determined by the board. So that's a fair summary that pretty much you have to do everything. Is that right?
The summary is as you read it out from the Act. Yes, yes, Council.
Now, you're aware this hearing is concerned with South Australia, and one of the issues that has been raised in the hearing thus far is the relationship between South Australia and the NDIS. And you've addressed this in your statement, if you've got a copy there, in paragraph 6. So participants who were residing in supported disability housing in South Australia when they transitioned to the NDIS were automatically eligible for Specialist Disability Accommodation, SDA, pursuant to the full scheme bilateral agreement between the Commonwealth and South Australia. Now, in terms of the reference to the bilateral agreement between the Commonwealth and South Australia, is that an agreement that you're familiar with?
I'm somewhat familiar with it, yes.
And what's your understanding of the purpose of the agreement in terms of the division of responsibilities between the Commonwealth and South Australia in relation to disability accommodation?
So the agreement set out the basis by which the state services or the state funded services and state involvement in disability would be transferred to the NDIS scheme. It set out some timelines for that to take place, a 2-year transition period, which was in fact shorter than a number of other states, provided for the continuation of some services to be retained by the South Australian Government for a longer period of time, particularly some of the residential services, which are then referred to as in-kind services. And that goes to the financial funding of the scheme as between the state and the Commonwealth, and provides for, as I said, some timelines for the transfer of participants and the handling of in-kind services.
And in terms of the description of in-kind services, at paragraph 20 of your statement, you say the NDIA does not hold structured data on how many NDIS participants are in receipt of in-kind accommodation services provided by the South Australian Department. Is that right?
Council, I believe that's not quite right. I think the statement says we don't hold data about how many of those people have sought funding to enable them to transfer out of that accommodation rather than the total number itself.
In terms of the total number, you have given some data in paragraph 21, and that's the number of participants, is that right, who receive in-kind service?
That's right.
And also a number who've exited.
Yes.
So you tell the Royal Commission that the participants in receipt of in-kind accommodation services by the South Australian Department is 520. So that's the total since December 2017, is that right? And the participants who've exited the in-kind accommodation services provided by the department since December 2017 are 77. So the people who would have exited the in-kind accommodation services would have then taken up accommodation services by private providers or other NDIS registered providers. Would that be right?
So I don't know that for sure in every case, but that would most likely be the situation, yes.
Right. Now, have you read Ms Boswell's statement that she's prepared for these proceedings?
No, I have not.
Well, she also gives some evidence about the operation of 2 bilateral agreements between the Commonwealth and South Australia. And she says, as at the 31st of March this year, there's 30...
Oh, sorry. I don't mean to interrupt you. I mistook the name. Yes, I have read Ms Boswell's statement.
So she says, as at the 31st of March this year, there are 39,608 South Australians who are NDIS participants. Does that accord with your understanding of the numbers?
Yes, it does.
And that DHS, so the department, is a registered provider for non-in-kind services, is that right?
Yes.
And with DHS registered as a provider for the non-in-kind services, what does that mean in terms of the relationship between the department and DHS? Sorry, department and the NDIS.
In that context, it just means that they are a provider of services as a registered provider in the same way that a for-profit or a not-for-profit organisation might be. So a registered provider can be a government agency, a not-for-profit, a for-profit, etc. And Ms Boswell's statement is simply noting that the South Australian government, in some sense, for some services, has continued or transitioned into being a registered provider under the NDIS scheme.
And is it the case that the transition is complete, but there still remains a date by which anyone in DHS accommodation will be fully transitioned to the NDIS?
So my understanding is that the transition is complete in the sense of people with disability previously in state-run programs have transitioned to the NDIS fully. Of course, there are also, in that number of 38-odd thousand, I think, a number of new people who are receiving supports from the scheme for the first time, who are not previously receiving supports under state-based schemes. What is still to happen, as I think I note in my statement at paragraph 22, is that the time for the transitioning out of the in-kind accommodation programs will continue through to 22-23.
And that...
I'm sorry to interrupt, but can I ask whether, is this arrangement about in-kind accommodation services unique to South Australia, or is this something that appears in the other bilateral agreements between the Commonwealth and the states?
Yes, Commissioner, it is something that does exist in other bilateral agreements. The timings differ. For example, Victorian operations have just ceased now, literally in the last month. So as opposed to the 22-23 date that you see here with respect to South Australia.
Thank you.
Now I want to turn to the 2 case studies that the Royal Commission has heard about over the course of the past few days, and they're the experiences of Mitchell and the experiences of Daniel Rogers and his family. So I'll start with Mitchell, and the Royal Commission asked you in the preparation of your statement to provide us with a chronology of actions taken by the NDIA in relation to applications for NDIS funding made or on behalf of both Mr Rogers and also Mitchell. Can I start with Mitchell? So in your statement, one of the attachments, which appears, Commissioners, in Hearing Bundle Volume C at tab 67, is the chronology. Now, we're going to see how we go here. I don't need that to come up on the screen, but I did want Mr Hoffman to have a hard copy, and I understand that there's a folder of hard copy documents. Just give him the whole folder. So, Mr Hoffman, I'm going to give you this, and I'm not going to ask you in detail about it, but if you need to refer to the chronology, let me know.
Thank you. Thanks.
So the Royal Commission has heard from Victoria and James, and they've told the Royal Commission that Mitchell became a participant of the NDIS on or around the 7th of May 2018, and that on the 18th of December 2018, Mitchell's first NDIS plan became available. Now, Victoria says that that plan covered Mitchell's core supports and capacity building, so that is some funding to assist him in improved daily living and relationships. And she says this was all in the context of the in-kind agreement between the NDIA and the department. Do you agree with that characterisation?
I'm seeking to answer, but I'm not sure exactly what is meant there. The plan, yes, would have contained the supports that you mentioned, including capacity building. If it was, as it were, cashing out the in-kind, then yes, if that's what is meant, or it would have continued with the in-kind provision being noted in the plan, but not a cash item because it's accounted for directly between the state and the Commonwealth.
All right.
I hope I'm addressing the question there. I wasn't quite sure.
So in the material that you've got behind tab 68 is a copy of the first plan. Have you had a chance to look at that before coming to give your evidence today?
Yes.
And does that assist you in terms of understanding what the funded supports would be if we looked at the plan, say, for example, starting at page 5?
Yes, it does, because I think it accords with the answer I gave previously where I was talking about the supported independent living in kind continuing, and you can see the budget amount there of $2, which is effectively a placeholder in the IT system to make sure it registers, but notes that the money is actually flowing in a different way.
And for just stepping outside Mitchell's plan, for an NDIS participant whose accommodation was provided by the South Australian Department, in terms of the in-kind arrangement as it might be described in the NDIS plan, would something like this be similar in other plans where you have a notional amount?
I think so, yes. That's my understanding of the sort of requirements of the computer system, that it doesn't zero out and then think it's not there, which is why a sort of $1 or $2 amount is registered.
Right. Now, Victoria...
That's its only purpose. It's not, there's no other purpose for why it is $2.
So Victoria said she wanted Mitchell to receive various therapy and source some day option activities for him, but her evidence is that the NDIS plan, because it was in kind with the department, there was no ability for her to source external providers, and she had to rely on the department sourcing and providing the therapies and the options for day activities. So does that, looking at that plan, or if you want to have a look at your chronology, do you accept that Victoria's understanding about how the NDIS plan worked for Mitchell at that time was right?
Yes, I do.
And Victoria says that Mitchell's 2020 plan, and that's in the bundle, but I don't need to take you to that, has released areas of funding from the in-kind agreement as she had requested, I think, in a review of the plan. And she says this has now given Mitchell the ability to appoint external coordinators and therapists to work as a team in providing Mitchell with the best care. So she's made an observation about those changes. Looking at, well, first of all, do you accept that Victoria's characterisation is correct, that there was an ability to free up some of the in-kind services?
In this case, yes, it appears that to have been the case, and some value of the in-kind was cashed out, as the phrase is, and put into the sort of cash version of the plan, then able to be used with the choice and control of Mitchell and his parents.
So how would people in South Australia who were in a similar situation to Mitchell and Victoria know how to navigate around the NDIS system to manage the in-kind versus cashing out, so that the participant could have some options outside all options being provided by DHS? How would they know how to do that?
That should take place through a discussion with the LAC or the planner in the context of preparing the plan or the subsequent reviews of those plans.
Now, I want to ask you now to turn to Mr. Daniel Rogers. So a copy of his chronology that you've prepared for the Royal Commission appears behind tab 29 in that bundle.
Thank you.
So again, I don't need to take you through it in detail, but if you need to refer to any particular date, please let me know. So the Royal Commission has heard that Mr. Rogers met the access requirements on the 29th of June 2018, and he became an NDIS participant from around that date. And the assistance provided through his plan at that time was limited because his accommodation services were also provided by DHS in kind. And Mrs. Rogers, and I'll perhaps go, if this is all right with Karen Rogers, if I go between Daniel and Mr. Rogers, I mean no disrespect in referring to Daniel as Mr. Rogers or vice versa. But the NDIS plan provided for Daniel's day option, but it didn't provide for any additional support before or after his day option or any respite care on the weekend. So the Royal Commission has heard evidence from Mrs. Karen Rogers that Daniel lived in a DHS accommodation, but that he had a day program at Windermere Parker Farm. So that was his arrangement. In February 2019, Daniel moved back to his parents' home, and Mrs. Rogers has told the Royal Commission that Daniel returning to the family home meant that modifications had to be made to the home to make sure Daniel was safe, and that required the plan to be reviewed. So in your statement, you have talked about an NDIS participant seeking to change their plans because they may change providers or there needs to be a modification to the private home. That's paragraph 7 of your statement. So it's the case, isn't it, that with Daniel moving from a DHS home back to his parents' home, that there was an obligation on Mrs. Rogers to notify the NDIA of a change of circumstance, and if she was seeking some funding to make modifications to a private home, then she had to initiate a plan review. Am I right in understanding that's what you're saying in paragraph 7?
Yes.
Right. Now, Mrs. Rogers told the Royal Commission that she contacted the NDIA to request a change of circumstances meeting in March 2019. Is that common, that to identify a change of circumstances that you would organise a meeting?
It is sometimes requires a meeting. It might be able to be done by telephone, but yes, there needs to be a process for a request for a participant requested review of the plan, a decision to do that, and then, or not, and then to actually make that plan review, yes.
In what circumstances might there be a meeting with the NDIS participant and their supporter versus just making an email request or notifying over the telephone?
Oh, it might depend on the preferences of the participant and their family as to how they want to do it. It might depend on the extent and complexity of the circumstances.
Is there a fixed procedure that the NDIA would follow as to whether or not a request for change of circumstances, particularly where somebody is leaving one form of accommodation into a new form of accommodation where the NDIA would have some work to do, as to whether there should be a meeting in person about that or whether it's simply a matter of deciding whether you want to give your update details or change of circumstances over the phone?
The process would, as I said, yes, there is standard operating procedures and guidelines for that, but at a high level, the answer is just that depends on the preferences of the participant and then also the complexity of the matters, the extent to which other people might need or want to be involved in that meeting and so on.
Right. So is the upshot it depends on the circumstances?
Yes, I think that's fair.
So Ms Rogers has told the Royal Commission that towards the end of April 2019, Daniel's NDIS plan was approved and that provided enough funding for Daniel to continue his day options, plus some additional funding for respite. But she says that his NDIS plan still wasn't enough to meet his needs. And she said at this stage she felt like she needed to go through the process of proving what Daniel's needs were. And she describes the process as being one of like having to prove that Daniel had a disability all over again. Have you heard that this has been the experience of people in working through the plan, that they feel that they have to prove that they have a disability all over again?
Yes, I have heard that criticism from time to time, yes. I would say, though, that without in any way seeking to diminish or disagree with the feelings and the experiences, the intent, or what is often trying to be done, is to fully understand the circumstances of the participant and what their needs are, and that may well require an understanding of their disability. And there are requirements in the Act phrased that way, so that the best possible plan can be put in place. And so there is a balance there, and staff seek to do that as well as they can. I've been quite open previously that we haven't always got it right every time, and certainly take this opportunity here to acknowledge that in some respects that is the case for Mrs. Rogers and Daniel, and I certainly regret that.
All right, so I won't take you through the, as you can see in your own chronology, quite detailed chronology about events in terms of communication, and you will have seen in that chronology Ms. Rogers describes a circumstance where she had to submit a review process very, very quickly and the stress that caused. And the chronology also shows a process of decisions being declined and review applications having to be made. But Mrs. Rogers gave some evidence this week to say that she looked on the internet and she discovered that a letter could be sent to the CEO of the NDIA to request an internal review of a decision. And she said, this might have been fairly shortly after you started, but she wrote to you on the 1st of November 2019 asking for help. So, Commissioners, you'll recall the letter is in Hearing Bundle A behind tab 22, and that might come up on the screen for Mr. Hoffman. I don't think he's got Bundle A with him. My Bundle A behind tab 22 has a letter to Mr. Hoffman dated the 1st of November. That's it. All right. Now, Mr. Hoffman, Ms. Rogers gave some evidence yesterday to say that it was her genuine belief that when the website said that you, as a person could write to the CEO to request an internal review, that this letter would make it to you and that you would read the letter. So, have you seen this letter before?
I have recently, yes.
And when you say recently, in the context of preparing for the Royal Commission hearing, is that right?
That's right, yes.
But not at a time on or around the 1st of November 2019?
That is correct.
Now, Mrs Rogers is under the apprehension that this would have come directly to you and you would have read it. What would have actually happened to this letter?
So, at the time, as you note, I started on the 4th of November. At the time, the process was that letters that were addressed to the Chief Executive came to the mail function. They were looked at there by staff, and depending on the content, they were then allocated directly to the area of the agency for action. In this case, being a letter concerning a particular participant and a particular complaint and concern, it went directly to the complaints area, and I think it was the case that it was actioned and contact by an agency staff member was made with Mrs Rogers.
Well, she gave evidence that there's been no response to this letter at all.
As I was about to continue on, as I said, the response was the phone contact to follow up on the subject matter and content of the letter, and that was done, and I understand done reasonably promptly.
Is this sorry, let me ask you about this while we're on it.
If I could just finish, please, Councillor.
No, just let me, wait. So, in your chronology, you say on the 1st of the 11th, 2019, that this letter was received on the 6th of the 11th, 2019. And when you say very promptly, your chronology says the response was on the 12th of the 11th, 2019. So you're saying in your chronology, what's described there as the NDIA phoned Mrs Rogers in relation to her feedback and confirmed that the internal review was initiated, because of the lapsed review, and that a decision had been made to decline the unscheduled review at that time, and it's describing her letter as a complaint, and that complaint was resolved. Is that what you mean by the response was prompt?
Yes.
So it took Mrs Rogers' letter of the 1st of November to be told by the NDIA that the internal review was initiated because of a lapse of a review, and the decision following that process was to decline the unscheduled review at that time. So how do you say that that's a prompt response to the matters set out in the letter on the 1st of November?
I was merely trying to say, in terms of the response to the letter, that it explained that it went to the complaints area and caused that phone call to be made to Mrs Rogers.
So the phone call is the response to the matters that are set out in the 1st of November letter?
And then the subsequent actions as set out in the chronology, yes, and the prior actions to that. The interaction between the request for a review not being made in time, causing an automatic internal review of that, as well as then a request for a review of the plan. And those interactions, yes.
Well, if you've got Mrs Rogers' letter there, she's saying that that she wanted an internal review, and that's what she was seeking, but the response from the NDIA was not to grant an internal review, but to tell her that a decision had been made to decline the review. Is that right?
I think the appropriate context is on the prior page, where the letter was sent to Mrs. Rogers to inform her of the decision to decline the plan review request. And then the letter follows in November, and then the phone call follows to confirm the advice given by letter in October.
But do you understand what Mrs. Rogers was doing is to say that she wanted to find out what to do when she was told in October that the decision was referred to an internal reviewer. She wanted to find out what was the status of that. She hadn't heard, and she's saying that the NDIA website has 243 links when looking for, quote, NDIS appeal, but it also states that a letter can be sent to the CEO, so I'm writing to you. The rest is so complicated. That's what she says in her letter. So I'm asking, do you understand that the letter that she was sending to you, and she believed that you would read, would be that you had a power to undertake a review and to help her work out what the situation is? Is that right? You accept that?
I accept that the website sets out that correspondence may be addressed to the Chief Executive. I was about to say earlier that upon my discovering that information that is addressed to me was not automatically coming directly to me in my office, I've since changed that, and such a letter now would be seen either by me or by my very close and small staff, which was not the case at this time, which I do regret. However, the invitation or opportunity to send correspondence to me as the Chief Executive is important. As I said, I actually spend some time each day looking at emails and letters directly from participants. It's a very important part of me attempting to stay aware and across with the way the scheme is performing at an individual personal level, as well as the data and so forth. But it does not create, and if this impression was created, then I regret that, but it does not create, and nor can it or should it really, an alternate pathway to proper decision making in accordance with the Act. So the process of doing a review under Section 100, an internal review, and then potentially to the AAT is the process for review and appeal of decision making. That should proceed with the appropriate delegated decision maker rather than me seeking to intervene because of a direct appeal to me in that process.
Why?
So it's a balance that I'm trying to make between, in terms of the way I have done the role, of balancing between staying connected and receiving direct feedback, direct correspondence and understanding of the way the scheme is operating without, as it were, creating an alternate and separate channel of decision making and process with the agency, which would be unfair to all participants in the way that operates.
Can I ask you, why then have you described that letter in your chronology as a complaint? If you're saying that the letter should be read as following particular legislative process or steps in the Act about review, why have you referred to it as a complaint?
I think it reflects the fact that Mrs. Rogers was, perhaps not unreasonably, expressing some dissatisfaction with what the experience she had received and that Daniel had received. As I said, it came from the mailroom to the complaints area to follow up, and that was the way it was categorised.
But there's a separate process, isn't there, in the NDIA for dealing with complaints, which is different to legislative decision-making in terms of meeting timeframes for making reviews, for those reviews to be dealt with. You agree with that?
Well, they often interact and intersect because quite properly and quite reasonably we shouldn't require participants and their families to be experts in the legislation. But yes, there is a process under the Act for decision making, and of course there is a complaints handling process too.
Do you accept, looking at your own chronology, that when you say that the complaint was resolved on the 12th of November 2019 by Ms Rogers being told that the internal review was initiated, but because of a lapse of review that the decision was made to decline the unscheduled review at that time, is an adequate resolution of the subject matter of her complaint?
It was an attempt to explain where the situation was up to, where the case was up to. It was not changing the decisions that had been made and the process that was made. I can understand that that would not necessarily be what Mrs Rogers, maybe quite properly, would have wanted to have received. But from the perspective of administering the document, the letter, it was actioned and the correct information as to the status of the situation was conveyed at that time.
Now, you're aware, aren't you, from the chronology, that then there was a series of events leading up to Mrs Rogers commencing an application in the Administrative Appeals Tribunal to seek to review a decision to decline a quote for the modification of the bathroom in their home. You're aware of that?
Yes.
And the matter was settled in the AAT, with the AAT making directions that the NDIA approve that funding and pay for the modifications. Right, you're aware of that?
Correct. Yes.
Now, in your statement, paragraph 16 to 19, you make some observations about home modifications. And I just draw your attention to those paragraphs without the need to go through them, Commissioners, in any detail. But is the description that you give of home modifications in paragraph 17 to 19, is that the arrangement that was in place when Mrs Rogers was seeking some funding to modify the bathroom in her home, or is this a new process?
So my hesitation there is simply that I know we have made improvements to the home modification process. I'm not 100% sure of the exact interaction of the timing of that with the timing of the Rogers case. If it's of importance to the Commission's work, I'm happy to clarify that by submission after.
I'm happy for you to take that on notice, and the reason I asked you is that I can't see any temporal aspect or time frames in the process that you describe in paragraph 16 to 19, and it just wasn't clear whether that was the process that applied to Ms Rogers. Now, Ms Rogers will say...
Sorry, may I ask a question while we're on the chronology, and I apologise if this is because I've misunderstood something that has already been explained. On page 3 of that chronology, we're told that Mrs Rogers requested a plan review on the 29th of August. Then in September, she sends through a review request form. October, she seeks an urgent update. And then on the 11th of October, NDIA sends a letter to inform her of the decision to decline the plan review request. The decision was referred to an internal reviewer under Section 100 of the NDIS Act. Under Section 100, is an internal review only available when someone requests it?
No, Commissioner. That is normally the case. There are about 20 or 25 decisions under the Act of reviewable decisions where they have to be requested. I think there are two examples where it is an automatic review for internal review. One of those being where we fail to make a decision as to whether to accept a participant requested review or not within the required time. We failed to make that decision within the required time, so it is automatically a Section 100 reviewable decision.
Well, if that's so, on my reading of Section 100, it's not a review under Section 100 because that only applies where requests are made.
Again,
that's what Section 100 says.
Without getting into, maybe this is something that we might come back to after. Happy to make a further submission and clarify that point, Commissioner.
Thank you.
I just want to finish on Daniel Rogers. His NDIS plan finishes on the 20th of June in about 11 days' time. Mrs. Rogers sent an email on the 25th of May indicating her need for a planning meeting as Daniel's circumstances have changed. She says she's only received a generic email to date, and she sent you an email to identify her concerns again, and she hasn't received a response. Now, I'm not expecting you to be across the current details of the plans, but if someone's plan is to finish in 11 days' time and they need a planning meeting to discuss changed circumstances, what should the NDIS participant and anyone supporting the participant expect in those circumstances?
Well, they should expect contact from the agency in order to proceed with either a plan review or a plan extension and so on. And I believe my office has spoken with Mrs. Rogers, including about the original letter, and will certainly be seeking to ensure that there is contact and that plan review is completed promptly.
Thank you. Commissioners, I'm about to turn to the next topic, which is to move to the NDIA's response to the two reports, the Robertson report and the safeguarding report. So if the Commissioners have any questions directly relevant to Mitchell or Daniel, it might be appropriate, Chair, to deal with those questions now.
Yes, thank you. I'll ask Commissioner Bennett whether she has any questions to put.
Thank you very much. One of the issues that I get the sense from the evidence provided by Mrs. Rogers and also by Victoria is about this flexibility, that a budget occurs, things are allocated, even in your form, you know, whether it's notionally $2, but it's down to $1,073. Do you get feedback that the flexibility, you know, a plan made a point in time for a certain amount of money, are you receiving feedback from clients to say, well, can't they have some direction in using the quantum of the envelope and actually use it for some of the bits that may emerge, or something might cost more, or something becomes a changing priority in their life? So an increased flexibility to use their envelope.
Absolutely, Commissioner. I mean, I think that is very much the direction that we are trying to take the scheme. I think that's very necessary. There is a degree of flexibility for use of the amount of money that is within the core supports category, but there are multiple other categories into which money is allocated. This stems from the way the Act is put together in Section 34 that requires the consideration of individual supports on a line-by-line basis, and the individual and incremental consideration of those supports to build up the total plan. And that has been confirmed in case law from the AAT to the Federal Court. That's something that I don't think works well. Doesn't work well for the agency, and more importantly, it doesn't work well for participants. I spoke about this at the Joint Standing Committee into the NDIS hearing at the beginning of May in Geelong, and I made an opening statement. there, which is only very short, but I think is very important in that it is referred to as Phoebe's Sundays, talking about an actual participant, Phoebe, and her father, and just noting that the hundreds, literally, of decisions that the agency has to make about each and every plan, and that the real difficulties that causes for participants and for ourselves. So the whole direction of the current scheme reform program, which you'll be aware of and is controversial as well, I would honestly say, but is towards the setting of an overall budget amount and giving much greater flexibility in its use to participants, in the view that they are the experts in their own lives and the lives of their loved ones, rather than a plan built up line by line, support by support. So I totally agree with you on that, and that is the direction of reform ourselves and the government is seeking to move.
And one last question. We received from evidence today from Ms Gale, the South Australian Public Advocate, Office of the Public Advocate, is that right? And going back to what Senior Counsel said about this capacity building, that it also shouldn't be a formula approach, that some people need that ability to assist decision making and on a more ongoing, not see if it's a one-off investment. Did you hear that evidence, and did you have a view?
Commissioner, can I jump in there? These are topics that I'm about to get to. I just wanted to try to contain the Mitchell and the Daniel Rogers specific questions, but I'll very much welcome your questions when I get to that very
That's
shortly.
fine. Thank you, Counsel.
Can I...
Commissioner McEwen, sorry, does Commissioner McEwen have a question?
Yes, Chair. A very quick supplementary question to Commissioner Bennett's question about flexibility. So is it fair to say from paragraph 19 that where you've said you're committed to delivering a simpler process for requesting home modification, that will be given strong consideration to the broader response that you said about looking at how we can make plans more flexible? Is that a fair characterisation?
Yes, Commissioner. I would say that I was talking more broadly about the total plan. The specific improvements referenced in 19, some of those we have already done, but certainly I would see the use of the plan. Basically, it would be, I'll be very brief, basically it would be about where there are expensive or significant home modifications, they would probably still need to be decided and approved separately and individually. But lower than that, small-scale modifications should be made much more simply and more in the control and the decision of the participant and their family.
Thank you.
All right. So I want to turn to Anne-Marie Smith. She was an NDIS participant. That's right?
Yes, that's right.
And you're aware, aren't you, following her death, that a report was commissioned by the NDIS Quality and Safeguards Commission?
Yes, that's right.
And also a process of review undertaken in South Australia through a safeguarding task force. You're aware of that?
Yes.
Now, you say in your statement that the NDIA conducted its own review into the circumstances surrounding Ms Smith's death. Is that right?
That's right, yes.
And you're aware of the South Australian Safeguarding Task Force report and the Robertson report being released on the 31st of July last year and the 4th of September last year, respectively?
Yes, that's right.
Now, I just want to understand what you mean when you say in paragraph 28, at the time, the NDIA's focus was appropriately on ensuring that participants could continue to access their essential disability supports during the COVID-19 pandemic, including participants who are considered vulnerable. Are you suggesting there that notwithstanding the two reports, that at that time the NDIA's focus was on a COVID-19 response rather than the specific issues and recommendations raised in those reports? Just trying to understand why you've made the observation there that your focus was appropriately on ensuring COVID-19 matters.
I think the paragraph 28 is saying that in fact, because of, not despite, but because of the impacts of the COVID-19 pandemic, there was already a focus on ways to better or more proactively identify and safeguard vulnerable participants, aligning with the recommendation. So it wasn't a case that because of COVID we weren't looking at those issues. In fact, it was the reverse. Because of COVID, we already had a heightened focus, as it says, on ways to better or more proactively identify and safeguard vulnerable participants.
So are you saying that the fact of COVID-19 meant that the NDIA had to focus on participants who were considered to be vulnerable in a way that hadn't occurred prior to COVID-19?
I think in that situation, particularly when there were lockdowns and people unable to leave home, there were concerns about the availability of workers. There were concerns about the entry of workers to residences or private homes and the potential for infection that might come from that. I think that did create an additional, and I think quite proper focus on the sort of issues that might arise from that. But I don't think it would, yeah.
But it's a case, isn't it, that the identification of vulnerable participants has always been part of NDIS planning processes. It hasn't had to wait for COVID, has it?
Absolutely, and I would not suggest and was not suggesting anything to the contrary there.
And in terms of the identification of vulnerable participants, essentially the tool from the NDIA's perspective is in the planning and development process, is that right?
In the planning process, yes.
Yes.
And other processes that are set out in my statement, yes.
Now, when you use the expression vulnerable, does that have a statutory meaning or some other fixed and agreed meaning?
No, I don't believe it does. I think it is being used in a more general sense, and I also note that, of course, it's important, as has been stated by other witnesses and elsewhere, that one must not equate disability with vulnerability, and in fact, there may well be a better phrasing and approach in terms of referring to at risk. I think Commissioner Head has spoken about that, and I would agree with his comments on it.
Oh. So I want to ask you about the planning process in terms of, as you describe in your statement, identifying, categorising and monitoring vulnerable participants. You've told the Royal Commission there's a range of ways in which that's done, but are we right in understanding that the primary way in which that is done is through data sources and analysis of data?
I'd say it's a combination of the data, the information that we hold, together with engagement with the participant in various ways.
Well, looking at your paragraph 30, you don't talk about engagement there, you talk about vulnerable participants being identified, categorised and monitored through a range of data sources and analysis. That's what you've said in paragraph 30.
That's right, but if you talk about the components listed under paragraph 30, a number of those involve qualitative or direct engagement with participants that lead to those components.
Right, and I want to touch in a moment on each of those areas very briefly. But you would have been aware from reading the report prepared by Mr. Robertson and his recommendations that he formed the view that it seemed to him that the processes adopted in Ms. Smith's case did not fully utilise the planning process as a safeguarding and risk detection measure consistent with the Act and the framework. You've seen his observations, haven't you? And if you need to have a look at it again, Commissioners, this you will find as part of the report in Hearing Bundle D behind tab 4 at page 45. If you want to have a look at that.
I would like to see it, please. Thank you.
Oh, So I've just given you page 45, and it's the second substantive paragraph which starts, "It seems to me that the process adopted in Ms Smith's case did not fully utilise the planning process as a safeguarding and risk detection measure consistent with the Act and the framework." And then there's a reference to section 33(2) of the Act, which says that that the plan must be prepared with, and then you'll see that with is bold and italicised, the participant and approved by the CEO. Right. Now, you've read that, haven't you?
Yes.
And do you accept that that assessment made by Mr Robertson is correct?
I'm sorry, there's a number of assessments in the paragraph. I mean, the first sentence?
Yes.
Yes, I think in that case, the planning process did not work as well as it could or should have as a safeguarding and risk detection measure.
Right. And in terms of Mr Robertson's recommendation, he makes his first recommendation. He says the Commission, and this is a reference to the Quality and Safeguards Commission, should act to identify earlier those people with disability who are vulnerable to harm or neglect. Every stage of decision making, including corrective regulation, should be alive to factors indicating that a participant may be vulnerable to harm or neglect. And he says this, although not within my terms of reference, the NDIA should also act in the planning process and continually. So you saw that recommendation?
Yes.
And you're aware, aren't you, that obviously Mr Robertson was not investigating the NDIA. His focus was elsewhere, but it's a case, isn't it, that submissions were made on behalf of the NDIA to the Robertson Review?
Yes, it was, yes.
And
information was provided. As he notes, I met with him and discussed these matters.
And to the extent that Mr Robertson has expressed these views and made recommendations, should this Royal Commission take it that the NDIA has also carefully looked at recommendations that are relevant to the NDIA?
Yes, you should.
Now, you're also aware of the South Australian Safeguarding Report, and in the same bundle that you have there, behind tab 5, is the what's called the supplementary report, but it's the final report. Could I ask you to turn that up, and in particular to turn to page 7? And at page 7 there's a description of the NDIA. Is this something that you've read before? And I don't expect that you would have read it today, but have you seen this before?
Yes, I have.
And just ask you to scan those pages on 7, 8 and to the top part of page 9. The supplementary report seeks to give a very high level overview about the operation of the NDIA. Would you agree with that?
It seeks to give what? I'm sorry?
A very high level overview of the processes of the NDIA.
It seeks to do that, yes.
And the task force has said in its report that the NDIA has not had a clear, transparent concept of vulnerability. That's in the final paragraph on page 7.
Yes.
See that? And the report notes that during the COVID-19 pandemic, the NDIA identified over 5,000 participants in South Australia who are vulnerable, and these people have had welfare checks conducted by the NDIA. Do you accept the accuracy of that statement?
I accept the accuracy of the statement that during COVID, the NDIS identified participants with whom we made welfare checks. I don't necessarily accept the first sentence of that paragraph.
All right. And over the page, the task force says, and I think the point that you've just made, just because you have a disability does not mean that you are therefore vulnerable. Some people may be vulnerable due to not being aware of what they need and what support is available for them. But they say this: having a process to identify potentially vulnerable participants is key, and having a single locus of responsibility vis-à-vis the participant is essential for good practice. The concept of vulnerability needs to be assessed on a case-by-case basis and is not static. Do you agree with that?
Could you just point me to the exact paragraph on page 8? Is it the...
It's the third paragraph. So the first paragraph is continuing from the page before. The second paragraph starts task force members, and the third paragraph is the bit that I've just read to you, having a process. Page 9.
Page 9, sorry. I was on 8. I beg your pardon. So that paragraph has a number of concepts, and I would need to talk about each one in terms of my view of it.
I'm just asking whether you agree with that or not.
I don't agree with every concept or principle that is contained in that paragraph.
All right, but do you agree having a process to identify potentially vulnerable participants is key?
Yes.
And do you agree that the process is one that has a single locus of responsibility?
That is the one that is more complex to deal with, and that is one that we're happy to talk about further and may wish to, as to whether there is a single person, if that's what's meant by locus, or a single, and that is the same person or sort of person for all participants or not. So that is why I was hesitating. I'm happy to go into that. But the idea of having certainly the process to identify vulnerable participants and then responsibility to do something about that and be aware of it, I do accept.
Well, it's a case, isn't it, that your view is that there shouldn't be a single locus of responsibility, and your view is consistent with the quality and safeguarding framework, that it is different players, starting with the participant, share responsibility for promoting the safety and well-being of a participant and working to reduce risk of abuse, violence, neglect and exploitation, and the role of nominees and statutorily appointed guardians is especially significant. That's what you say at paragraph 75 of your statement.
Yes, that's
so
right.
Do we take it by that it's the NDIA's view that looking at safety is a shared responsibility?
That would be one way of putting it, yes.
And would you accept that shared responsibility carries with it some difficulties, because shared responsibility requires there to be clarity around who has responsibility and how any shared responsibility should be discharged? Do you accept that?
Yes.
And the concept of shared responsibility can also be very difficult if one is looking at accountability, if one or more parts of those with shared responsibility fails to discharge their responsibility. Do you accept that?
Not necessarily. I think there are many examples of shared systems that doesn't preclude accountability. I don't think it necessarily follows, no.
When you talk about shared responsibility, do you mean shared in the sense of equal responsibility?
Not necessarily, no.
What then does shared responsibility mean in terms of who bears primary responsibility and others who may have subsidiary shared responsibility?
Well, I think it depends upon the circumstances of the particular person and their particular situation. So we said you start from the presumption of capability of the participant themselves, that is not always there, of course. So then you look to the person who has the nominee or guardian responsibility, which may well be family members, and then proceeding to the state as the guardian of last resort and their decision-making responsibility, including as to matters of health and safety and well-being. Then in the NDIS context, you come to the role of the NDIA and its sibling agency, the Commission, and our roles with our staff and partners in the LAC, and they clearly have an ongoing role through the planning process, which is identified in the framework, as you said, as an important component of safety and well-being. And then thirdly, you move to the actual service providers themselves and the importance that the service provider has a responsibility there, as they are often the party most in contact on a day-to-day basis with the participant.
But that's a system that requires all of those component parts to, first of all, understand what their responsibility are, that may be. Secondly, to have the capacity to discharge that responsibility. And thirdly, that there is a system that wraps around that shared responsibility so that those involved can be accountable. And that doesn't that become difficult when you have a number of shared players?
Not necessarily, no. I think it provides, it does require an understanding of responsibilities, as I just tried to outline in my prior answer. But in some senses, it provides overlapping and strength in depth, as it were, of different players having responsibility and accountability with for safety and well-being. I think that is, in some ways, preferable to a system that may be liable to a single point of failure.
Now, Mr Head says in his statement that the NDIA planning process seems most likely to be the best source of information in relation to, firstly, whether a participant can raise concerns themselves, secondly, whether a participant has natural supports, and thirdly, whether a participant is at risk of losing their natural supports. So that's what he says in his statement. If you need a reference to that, it's at paragraph 84, page 21 of his statement. But the Safeguarding Task Force noted as the first safeguarding gap is that potentially vulnerable participants are not routinely identified through the planning processes. So against that background, I want to ask you about the planning processes that you've described in paragraph 30 of your statement, and I think you were about to start to deal with those a little earlier. So if I can ask you to turn to paragraph 30, and you've identified the different methods. Now, before I ask you about each of those methods, to what extent have people with disability been involved in the development of any of the methods described in subparagraph 30A through to G? Well, let me put it simply.
No.
Is there a consultation process?
Yes. I just was trying to scan the list before responding, etc.
If it's easier when we go through each one, if you want to come back and assist me on each topic as we go through it, whether people with disability have been consulted in the development, I'm happy to do it that way. But I'm thinking we might shortcut if you can do it globally.
I was going to say, yes, they have, particularly in respect of A, F and G, which go to our pathways work, which was work done particularly in 2017 and 2018 that established the different planning pathways, and there was significant consultation and collaboration in the design of those.
And what role, if any, has the Independent Advisory Council had in reviewing any of the methods described in A through to G?
That's a question I'm not 100% sure of the answer now. Some of that work, as I said, referred to 2017 and 18 timeframes before I commenced, so I'm not 100% sure. I know that currently the IAC is working very closely with us on issues of risk, and they have a piece of formal advice I think has been tendered, or an early draft of has been tendered to this commission. So in that sense, some of these issues are involved, yes.
Right. And to the extent that the Convention on the Rights of Persons with Disabilities is relevant, to what extent has the CRPD been used as a means of checking the operation of each of these sources, or some sort of audit against the CRPD? Do you know if that's been undertaken?
No, I don't know the answer to that. I would be speculating. I'll be very happy to come back and make submission on that point.
All right. So I just briefly want to deal with each of the methods, because you've described them from paragraph 31 and onwards. So the first one is risk streaming, and the NDIA applies a risk streaming method for all participants as they enter and interact with the NDIS. And it's the case, isn't it, that streaming refers to a predicted level of assistance or support that a participant may need to navigate the NDIS pathway, but streaming doesn't impact on the level of reasonable or necessary supports for a participant. So is it the case that streaming works like this, that everybody has to be streamed, and that the streaming process is really designed to look at the level of assistance and supports, but not necessarily to identify vulnerability per se?
No, counsel, I don't think that follows. What the streaming is seeking to do is to allocate to a pathway, two of which are managed, which is the majority of participants, about 70-odd%, managed with the partners, the local area coordinators, and then 30-odd% managed within the agency. You're correct that it doesn't go to the reasonable and necessary funding and supports, although there is a very clear correlation between the size of the package, the size of the funding that is ultimately set, and the streaming. So in that sense, as I said, there's a very close correlation between those two things. But that risk streaming does use as factors things that do have been identified and agreed as indicating risk factors.
Right, and there's 4 streams, isn't there? General, supported, intensive and super intensive.
And then I would probably add the 5th being the complex support needs pathway.
Right, and that's a separate item though that you've identified,
yes,
in paragraph 30, so we'll come to that. So in terms of how the streamings work and where you might end up by way of stream, you've referred in your statement at paragraph 33 to the standard operating procedure, and a copy of that is provided behind tab 25. So I don't need to take you any further into that, but just finally on the streaming. The streaming can be updated at any time and reassessed during plan monitoring and plan review processes, as well as when new information becomes available. Now, is that a matter of course? So I've just asked you earlier, for example, in relation to Daniel Rogers and Mrs. Rogers saying she wants to have a review of the plan. Would a request for a review automatically trigger a review of the streaming? Or is it the case that the review of any streaming as to whether you're in general or intensive or the like comes about in a different way?
No, I believe it comes about as part of the review process, the plan review process.
Now, the second area you've identified is something called the Participant Risk Assessment Tool, And at tab 22 in the material, that relevant system is identified. But this you describe in paragraph 37 is a tool intended to evaluate participant risk during a planning meeting. So it occurs after streaming, and it's completed with details of vulnerabilities or risk relevant to the participants' current circumstances. And then you've listed a number of areas of vulnerability, from physical, mental harm, financial harm, undue influences, unsafe home, unsafe in the community, and vulnerable to exploitation. Is it the case that this assessment tool requires a face-to-face assessment between a planner or a local area coordinator? Does this have to be a face-to-face exercise?
No, it does not necessarily have to be a face-to-face exercise.
Well, if it's not face-to-face, what would be the way in which the tool is exercised? Is it an online process, a telephone process?
It might be telephone, or it might be video call.
And if this is a process designed to evaluate participant risk, and it's done during a planning meeting, how long on average would a planning meeting take to properly apply this assessment tool?
That's getting to a level of operational detail that I'm not best placed to answer here and now, but it's an important question. I'm very happy to provide that information.
Right. And we've talked earlier about there not being a clear definition of vulnerability. So what does vulnerability mean in relation to the operation of this tool? And in particular, and you can use any of the examples that are set out there, vulnerable to physical harm, vulnerable to mental harm. How do those different vulnerabilities, how are they detected, and what do they mean?
Well, they're detected through the questions that are asked, and I think the document that is referred to, or at least, yes, referred to in paragraph 40, sets out some of those questions and approaches to doing that.
We might have a look at that. So if you turn to tab 22 in the folder that you have there. And in particular,
is it the second?
It should have on the front of it hearing bundle C. And it's tab 22.
Yes, thank you.
And if you turn to page 14. And I take it you're familiar with the standard operating procedure?
Yes.
And in terms of some of the questions that might be asked, the area of identifying vulnerabilities and capabilities starts a couple of pages before at page 12 with some instructions. You see that?
So which page, sorry?
So I want to ask you some questions about page 14, but just to provide a context, page 12. So there's some pagination in the bottom right-hand corner.
Yes.
So paragraph 3.4 says identifying vulnerabilities and capabilities. And then it sort of sets out some guidance notes to the process to be followed. You agree with that?
Yes.
Now, back to page 14. Looking at this document, is it right if we look at the boxes which are framed by the red border, that would represent something that has to be completed, like an online form that has to be completed?
Yes, it's been completed by the staff member on their system.
So some of the questions that might be asked on page 14, for example, does the participant have a support network of friends and family who are able to assist them? And there's 4 options there. And so identifying one of those 4 options would identify whether somebody might have relevant supports. Is that right?
That's right, yes.
And then in terms of participant vulnerability, you'll see the language that you've used in your statement, that appears in the box under number 2, is that right?
That's right, yes.
But that description, vulnerable to physical harm, you agree is a conclusion, and that you need to have certain information to make the assessment of vulnerability before you could tick the box. Do you agree with that?
Yes, I think so.
And can I suggest to you, looking at the whole of that document, that there isn't anything that helps the person make an evaluative process as to whether somebody is vulnerable. Do you accept that? It builds in a conclusion of vulnerability, not a method of identifying vulnerability.
The method of it reaches a conclusion, and as reflected in the box at 2, having gone through the questions at 1 and 3.4.3.1 in terms of the conversation that will have been had in order to reach that conclusion.
Now, you're aware, aren't you, one of the recommendations made by Mr. Robertson in his report, recommendation 5, was directed to the importance of face-to-face assessments of vulnerable participants. You're aware of that?
Could I just...
Yes, of course.
See
If
that?
you want
Which,
tab...
is it the other folder? Isn't
Yes, sorry, I'm trying to
No.
speed up a little bit, and I don't
I'm not trying to slow
cause
you down.
So that's in bundle D, behind tab 4.
Yes.
And there's a summary of the recommendations on pages 7 and 8. And if you have a look at recommendation 5, it says, because of the inherent limitations in record-based systems in preventing harm or risk of harm to vulnerable participants, the Commission, and this is a reference
Yes.
to Mr. Head's Commission, should conduct occasional visits to assess the safety and well-being of selected individual NDIS participants, whether or not a complaint has been made or a reportable incident notified. And he says this, the Commission should miss no opportunity for face-to-face assessment of vulnerable participants, although not in my terms of reference, the NDIA should also act. And then he gives a more fuller description of the reasons for that recommendation at pages 43 to 47.
Yes.
So, and Mr. Brueggemann, who gave some evidence to the Royal Commission earlier this week, also commented on the importance of planning being face-to-face and preferably within a person's home. Now, in terms of this exercise that is used for the participants' risk assessment tool, would you accept that you may get different results depending on whether or not the assessment is face-to-face versus something over the telephone?
Yes, in theory, yes.
Let me give you an example.
Sure.
We heard this week in relation to where Daniel Rogers lived before he returned to live with his parents, and that an audit report was conducted of the particular residence. And the first thing that people noticed when they walked through the door was the odour. So just being in the physical location and observing the circumstances or the odour, that would help you identify a factor that may be relevant to looking at vulnerability. Do you accept
yes.
that?
Yes.
And that over the phone, someone's not going to say, my house smells. So I want to test with you, if the planning process is designed to detect vulnerability, do you accept it has got significant limitations if there is no face-to-face component in that?
I certainly accept that it is, as Mr. Robertson said, we should not miss an opportunity for face-to-face assessment of participants, particularly potentially vulnerable participants. and that may well be through the planning meeting. I just go back, of course, to 2 points. One, and this is a judgment and a balance, but one, the preferences of the participant in terms of the way meetings are carried out. And then secondly, just the obviously practical one over the past year in terms of the difficulties that COVID has caused for face-to-face type meetings.
Well, the COVID situation...
In general, I accept the point that we should miss no opportunity for face-to-face assessments.
But the COVID situation, in a sense, has really brought to light that when people are isolated in their own homes, that loss of connection and reliance solely on technology and processes highlights weaknesses in systems to detect vulnerability. You'd accept that?
I think, I'm not sure it necessarily highlights the weaknesses of systems. It in itself can create vulnerability and can weaken the ability of our processes and systems and other agencies to detect that, yes.
Right. Now, I want to come to the complex support needs pathway, and that seems to be an important element. But before I get to that, there's 3 others which you describe as customer relationship management, participant dashboards, and a PCI framework, a participant critical incident framework. So in terms of the customer relationship management systems alerts profile, you've dealt with this at paragraphs 41 to 45 of the statement. But is that something that's not predictive but more reactive? So that if an event occurs and an alert needs to be added to a participant's record, that there's a system of having an alert added to the participant's record?
Yes, that's right.
So it's not a planning tool per se.
Yeah. So then it's when a staff member comes to have or prepare for an interaction with a participant, the existence of one or more of those alerts is an important factor as to how they might carry that out.
Right. And then the participant's dashboard, so that's available to all NDIA staff and the LACs, and it allows you to view the participant information drawn from the customer relationship management system. So is that the flip side of what you've described as the customer relationship management alert process? So this is from a participant's perspective, is that right?
No, not. What I would simply say is that the dashboard pulls together in a relatively easy to use way for a staff member relevant information about the participant drawn from the CRM database. That will include risk alerts and profiles as one of the things that you would see on the My Dashboard.
Right. And the participant critical incident framework, which you've described in paragraphs 49 and 50, is it fair to say that that's not planning per se, but that's a system in which the NDIA and partners, who I'm going to ask you who they are in a moment, is that they manage critical incidents. So that's a response mechanism rather than a planning mechanism. Is that right?
That's right, yes.
And the partners there is a reference to whom? The Quality and Safeguards Commission?
No, the first line of 49 referring to the LAC partners, the Early Childhood partners, a National Contact Centre partner, etc.
Right. And this critical incident framework is, if a critical incident of the kind described in paragraph 49 occurs, then this is to set off the right pathways about how to respond to that incident. Is that right?
Yes, to make sure that staff know what to do if they become aware of one of those sorts of events or things, and that it is dealt with properly, and that to the extent possible, harm can be minimised going forward.
All right. Now, I'm conscious of the time and commissioners may need a break, and I've probably got another 60 minutes or so, an hour to go, if the commissioners would like a short break now, because I'm about to move to the complex support needs pathway. Otherwise, I'll keep going.
If Mr. Hoffman is comfortable to keep going, and unless Commissioners Bennett or McEwen show signs of wanting to flee, then I suggest we keep going.
We keep a close eye on, yes, we'll keep a close eye on the commissioners.
If any Commissioner keels over, we'll know it's time for an adjournment.
All right, thanks. All right, so I want to ask you then about the complex support needs pathway, and I want to start with this. Mr. Head, in his statement, and this is at paragraph 44 and 45, says that the NDIA is currently developing its, quote, vulnerable participants framework, and he says he understands that the vulnerable participants framework currently includes the following themes and definitions with data indicators for each theme. So housing, financial, family, domestic violence situations, health plan issues and provider issues. And we didn't see you describe a vulnerable participants framework in your statement. And we have assumed, and please tell us if our assumptions are wrong, that the complex support needs pathway is the vulnerable participants framework. And if I'm wrong on that, can you please help us with what is the vulnerable participants framework?
Yes, Council, and I'm sorry if it wasn't as clear. No, they obviously interrelate, but the complex support needs pathway is one thing. What is described under the next subheading, the participant check-in model, and particularly paragraphs 56, 57, 58, and that is what Mr. Head is referring to. That's the matching piece.
All right. Well, the reason I asked you that is looking at the complex support needs pathway at paragraph 52, is the relevant situational factors or criteria that lead to a referral to the complex support needs pathway seem to include some of the factors that Mr. Head has identified in his statement, which may be indicators of vulnerable participants. So somebody who's homeless or transient, a person with a history or propensity for experiencing financial abuse, or vulnerability where a person has limited informal support networks. So looking at what Mr. Head's described and then looking at the CSN pathway, what's the difference between them?
Okay. So as I said in my previous answer, there is clearly an overlap between the two. The CSN pathway leads to the identification of a group of participants, I think it's about 10,000, who are treated in that pathway, and that is they are in a particular or managed supported service by a particular branch with some of our more experienced and senior and capable planners. They're not involved with the LAC partners. We manage that directly and their plans directly, often almost always working very closely with support coordinators and others. What then goes on under the participant check-in model is broader, where we are identifying a wider group of participants who may be at risk based on the sort of factors listed at 56 and then as being refined as per paragraph 57. And that goes to the check-in model where we are making direct contact with the participant, either by phone or face-to-face, to literally check in and have a conversation rather than only talking with them for the transactional purposes of a plan review or a plan update, etc.
So is the check-in model the model that was developed in that early phase of the COVID-19 pandemic where there were a lot of lockdowns and the NDIA then said we're going to check in on people who we think may be vulnerable.
Yes, so...
I think you've given some evidence in your
my
earlier
prior
statement
I
about
think,
that,
yes.
yes.
And I think that was so well received by participants and, frankly, motivational to our staff as well, that it was something that we thought, hey, you know, we should keep doing this and we should refine it and get better at it and embed it in our general operating practice rather than the sort of one-off crisis pandemic response. And so, yes, it came out of that, but it is now ongoing. And so separate to the plan review process where we have an engagement, we now have the check-in process, which is completely separate. And as I said, trying to develop more of a relation. Don't want to overstate it or over-promise it, but develop more of a relational engagement than just a transactional one about the plan review. So year to date, or up to May, we've made sort of 7,000 contacts outside the plan review process. In the quarter to March, we did something like 94,000 plan reviews. So that's where we engage, but then this additional non-review based thing was about 7,000 for the months to May.
So if there's about 10,000 NDIS participants who are in the complex support needs pathway, would those 10,000 be in the cohort of the 70,000 that you referred to in paragraph 55, being vulnerable participants who check-ins had occurred during the COVID period? So is the 10,000 of the CSN automatically part of that larger cohort of vulnerable participants?
I don't recall that they were automatically, but by the nature of the factors involved, there would be an almost identical overlap.
Right. So with respect to the 70,000 vulnerable participants that you've referred to in paragraph 55, Mr. Head says in his paragraph 47 that he thinks that the NDIA currently estimates the vulnerable participants through the Vulnerable Participants Network to be something in the order of 25,000 to 30,000 participants. So I just want to understand your 70 and his 25 to 30,000. Right, so do you have an estimate at the present time, applying the participant check-in model, that the number of participants would be in the order of 25 to 30,000 people?
I'm not 100% sure of where Mr. Head of that number. Of course, part of the issue is it's not a binary yes, no, 1, 0 type thing. There is, by definition, a continuum of risk depending on the factors you bring into bear and the fact, of course, that they can change over time as well. So I'm not sure and that's why I'm hesitating on the numbers, because it's true we made contacted 70,000 people in the COVID VPOC program. I don't think it's helpful necessarily to say there are X thousand vulnerable participants and therefore 450,000 minus X non-vulnerable participants. I think that has risks as an approach in itself.
How were the 70,000 vulnerable participants identified during the height of the COVID pandemic?
Through the factors listed in 56.
And Ms. Smith was not identified as a vulnerable participant prior to her death on the 6th of April, was she?
She was not sought to be contacted before her death, no. That's not quite the same thing as what you asked, though. Her factors against 56 would have, but she was not contacted as part of that program at that time before her death.
Hindsight can give you great benefits. With the benefit of hindsight, there'd be no question that she was a vulnerable participant. Do you agree with that?
Oh, it's not. yes, I mean, there is no question that she would have been contacted in that program if she were still alive. Now, I know that sounds hindsight-ish or harsh. It's not meant to be. I'm simply saying, yes, you're quite right that the factors identified in 56 would have flagged her, and so she would have been contacted as part of that, or attempted to be contacted as part of that program, because it was ongoing longer than April.
And looking at the items that you've identified in paragraph 56, they themselves are quite broad, and where you've got a scheme designed on choice and control and people living alone, it's not the case, isn't it, that simply living alone creates a vulnerability?
No, I would agree, yes. That was my point about it doesn't help to have a binary yes-no approach on this, I believe.
Right. So in light of what we've been talking about, which is the planning process to identify risk, can you help the Royal Commission understand how then does this process of the participant check-in model or the vulnerability participant framework model guarantee that you are going to catch the Anne-Marie Smiths into the future?
Well, with the best will in the world, there are not guarantees in this life or in our approach. But the approach we have of using multiple factors of, as I said, deliberately not treating it as a binary yes-no and thereby potentially excluding somebody, seeing that it varies over time, and expanding our contact with participants through the check-in model and then through the continued improvements to the planning processes, give us the best chance of playing our part in identifying and protecting participants who may be at risk.
Now,
I'm sorry to interrupt, but part of the difficulty with a concept like vulnerability, whether you want to use that or at risk, is that it has different meanings in different contexts.
Yes.
As I understand paragraph 56, it lists criteria that we use to determine vulnerability or people who are at risk in the sense of being at risk of contracting COVID-19 and suffering severe consequences as a result. That was the object, wasn't it?
No, Commissioner. We weren't able or capable or wanting to make judgments about vulnerability to infection. It was merely that, well, not merely, it was that during the pandemic and some of the factors that Council referred to in terms of lockdown, potential disruption to normal supports, we thought people with these sorts of factors might be most vulnerable or at risk of a range of harms, and therefore we should seek to up our level of contact with them. It was not about their infectability or infection risk, if I use that word properly.
Second line of paragraph 56 suggests that vulnerability to the virus itself was one of the aims of the project, doesn't it?
Yeah, it does mention that, but I would say my focus and our focus is on the rest of the sentence, vulnerable should their services be discontinued or disrupted. I mean, it is true that there is also, and I'm not pretending to be an expert in the infection components, it is true that, as I understand it, some of these factors may contribute to infection risk, but the primary focus, which is why we've continued it on, is about vulnerability, about services being discontinued or disrupted, and other harms.
Ascertaining whether someone was at risk of contracting the virus and serious consequences if they did would have been an exceedingly useful thing to do, wouldn't it?
Whether that was probably, and I would say that's probably a matter for health services, and I know they were seeking to do that. But I wouldn't disagree with you, Commissioner, no.
That's precisely the point. At a hearing dealing with the immunisation program for COVID-19, we were told that the reason that people with disability in supported accommodation who were within phase 1A were pushed down as far as priority was concerned in favour of aged care residents was because a judgment was made that all aged care residents are more at risk than people with disability living in supported accommodation. If there had been, in fact, an assessment of people within such accommodation who are at risk of contracting COVID-19 or serious consequences therefrom, then there would have been a mechanism to ensure that people with disability received an appropriate level of priority. Would there not?
Commissioner, it's not my area of expertise to comment or responsibility on those decisions. I think it is not unreasonable to point to the relative infection and death rates as between aged care environments and disability environments through last year to support that judgment. However, as I said, that judgment and decision is not, was not a matter for the agency or myself.
Why not? Why not?
Because that is not the allocation of responsibilities that the government has put in place for the management of the vaccination program.
No, but you wanted to find out, you've got it here yourself, you wanted to find out whether the people that you were looking at were in fact vulnerable to COVID-19. That was what their welfare in that respect was part of the concept of vulnerability, was it not?
So the factors we used are the ones that are in our knowledge, which are A to J. They were the factors, the knowledge that we have, that we used to determine the people we contacted during the VPOC program, and that was termed vulnerable in that sense. That includes both vulnerable to the virus itself, or, as you've noted, or particularly vulnerable to the services be discontinued. I don't think, however, we were seeking or implying that there was great epidemiologically or health or infection control knowledge behind the linkage of A to J with that question of vulnerable to the virus itself. These are the factors that we know about. They seem reasonable. They do, as other work has shown, they do go to this wider question of at risk, and that was how the cohort was determined.
Well, the only other point I would make is that paragraph 53, you refer to personal factors or criteria leading to referral to the CSN pathway included multiple diagnosis, clinical complexity of disability, both of which are closely related to vulnerability to COVID-19 or the consequences of contracting the virus, are they not?
I'm not aware of the evidence of that in terms of given the very low rates of infection in the disability community. I'm not, as I said, not an expert in that. I think 53 stands on itself in terms of its relevance to the CSN pathway.
Yes, thank you.
In terms of the CSN pathway, paragraph 69 of your statement, you make this observation that those planners frequently deal with the most vulnerable NDIS participants. And so the cohort of CSN planners are more highly trained and experienced planners. And in terms of being more highly trained and more experienced, is that to identify those who are in the CSN pathway having that level of complexity, also identifying vulnerability? So I'm just trying to make that link, and I was asking you about that before.
Yes, so I think, so they're more high, so the question is, Council, sorry.
So just look at 69.
Yes.
And I was asking you earlier about the relationship between the CSN and the Vulnerable Participants Network. So I asked you about the 10,000 who are in the CSN network and whether they're a cohort of the 70,000 that you've identified. Looking at how you find your way into the CSN pathway and the supports that you have while you're in that pathway, you have the assistance of planners who you describe as more highly trained and experienced planners who work closely with the participant. It's the case, isn't it, that if you're in the CSN pathway with planners with that relevant expertise, that if there are the risk factors that might cause a person to be identified as vulnerable, that they're likely to be picked up because of the planners and because of the framework that the CSM pathway describes?
I would hope so, yes. I mean, that's the nature of the criteria that go to being in the CSN pathway, as I said, have a overlap clearly with criteria of risk and vulnerability, and the planners who work there. But the focus for that group is the complexity of their needs and supports, and the requirement for often close coordination of those supports across multiple service systems, as is mentioned there in the third line. And that's really where the expertise and experience of the planners comes to bear.
And it's more likely that people in the CSM pathway have more static needs, and they're more clearly identified in terms of what those needs will be over a particular period of time.
Not necessarily, no. In fact, can be almost the reverse, that these are people whose lives are not static, not in any sense disrespectfully, but can be somewhat more chaotic, which is one of the things that gives rise to the complexity of their support needs.
Right. I've raised that question of static because, as you've referred to in paragraph 71 of your statement, that Mr. Robertson identified that being vulnerable or being at risk of harm or neglect is not static. And a person with disability may become vulnerable or may be vulnerable at one point but cease to be vulnerable on an ongoing basis. So a crisis like COVID-19 may heighten vulnerability, do you agree?
Yes.
But a crisis situation, for example, family violence, may heighten vulnerability at a particular moment in time. So in terms of the way in which you use the participants check-in model, which you've described at paragraph 72 and following, please take a moment to look at that. But in summary, this is a process that relies on check-in conversations either on the phone or face-to-face, that's subparagraph B. But this is not a process really designed to deal with vulnerability in a crisis situation, say an acute crisis with family violence. You agree with that?
No, it's not a process designed to deal with an acute crisis. We have a crisis service issue framework and process to deal with those sorts of cases as they arise. In doing this, in these contacts, it might well identify crisis situations that are occurring at that point in time.
But that might just be good luck and coincidence in the timing rather than by design, is that right?
That's right, yes.
And in terms of this process, it has to be initiated by the planners or the LACs, and they arrange the time with the participant to have in what you describe as a check-in conversation, either by phone or face-to-face. Is that right?
Yes.
So this is not a process where a participant can contact the NDIA and say, I'm in crisis, or my circumstances have changed which have put me in a situation of vulnerability. For example, if your family members receive a letter anonymously making death threats. Now, I know that applies to the situation in South Australia and Victoria and James's circumstances, but if Victoria and James and Mitchell were fully NDIS participants and receiving NDIS services in relation to Mitchell's accommodation, this model would not have provided them with a way of dealing with that immediate crisis where Mitchell became vulnerable by circumstances completely unrelated to his disability or to the services that are provided. Would you agree with that?
That is right, but it is not intended to. There are other processes that I mentioned very briefly before to handle that sort of situation. And in that example, contact to either the planner or the contact centre would initiate the participant critical incident framework and process, including, in that case, potential referral to police or whatever was the appropriate action under that framework.
So coming back to what vulnerable means for the purpose of this framework, the vulnerability really depends on particular characteristics or circumstances of the person rather than the circumstances in which a person may find themselves in that creates the vulnerability. Do you agree?
Not entirely, no. I think there are factors there that go to the particular circumstances of the individual, but also to their surrounding circumstances in terms of their living arrangements, their family arrangements. So there is a range of things. I accept it doesn't go to those, what we might call shock events or etc., but then nor can it or should it is it designed to, and there are other processes and avenues to deal with that sort of situation.
And Mr McNaughton gave evidence in Public Hearing 13 a couple of weeks ago, and one of the issues he was asked about was homelessness. And he made the point, I think, very clearly that the NDIA is not a homeless service. And you'd accept, wouldn't you, that NDIS participant who's at risk of becoming homeless is a person who would have to be characterised as vulnerable. Would you accept that?
At that point in time, yes.
Now, if as I understand the evidence from a week or so ago, that if the NDIA is not there to assist a participant who may become homeless, who in those circumstances addresses the vulnerability and provides assistance to a vulnerable NDIS participant?
So the responsibility for crisis homelessness rests with the relevant state and territory governments. Clearly, and that is the nature of multi-system supports, clearly there needs to be engagement and coordination, and our staff play their role in doing that. As it happens, as Mr McNaughton may have said, I don't fully recall, but we do use STA, short-term accommodation funds, sometimes in those sorts of circumstances, but it's important to maintain the agreements that Commonwealth and all state and territory governments made as to the delineation of what is NDIS and what is not, without that seeking to, but always trying to make sure that that is relatively seamless to the individual involved.
Do you accept, looking at the NDIS scheme as a whole, the assumption is that if you are funded under the NDIA for your accommodation and your services, that in some circumstances has allowed state governments to step back from service delivery? Do you accept that with the state government stepping back and the assumption that the NDIA is becoming the safety net for people who are participants, that leaves a vacuum for both identifying and managing risks for NDIS participants in these circumstances of crisis such as homelessness?
So I accept that, or agree that the states have stepped back from the things which have been agreed to be the responsibility of the NDIS. That's by definition. I don't accept that, and nor would the states accept that they have stepped back from those things that remain under those agreements their responsibility, which includes homelessness and crisis accommodation. So I don't think I would accept that a vacuum has been created. I accept that there is an ongoing need for coordination in order to that, as I said before, these multi-system and multi-government supports are relatively seamless to the individual involved.
Well, who then becomes the provider of last resort?
Well, that depends what service we're talking about being provided. Provider of what? in the
Well,
last...
if you just take the homelessness
Sorry, I'm not
one-
trying to be difficult, I just
Yeah.
generally want to understand that...
But the homelessness one, for example. So just thinking in relation to Mitchell and Daniel and their circumstances, is both were involved in situations that became a crisis, and the crisis arose in the context of the safety in their homes and consideration about where they go. If they had been NDIS participants and there needed to be some action taken to avoid homelessness, who then becomes the provider in effect of last resort? So it's different to somebody who may be evicted from their home, but these are crises not of the participants' making, but circumstances where being able to remain in their homes may increase their vulnerability. So who becomes their provider of last resort in those circumstances?
So the responsibility, and this happens right now, the responsibility of the agency is there, and we regularly work at the local level and then through our critical services issues response, CSIR, where we have an escalated pathway and contact points with state and territory governments to resolve those exact circumstances. So there is a well-defined ongoing day-to-day operation at the local branch and state level, and then with escalation points to coordinate exactly those sorts of circumstances. Where the person may end up living, if it's a homeless example, in the immediate term or the medium and longer term, is not the provision of one, is not provided by one organisation, but may be one of many providers who are involved in that provision of those sorts of services.
Right.
So I just think trying to tease out what provider of last resort means is what I was trying to do in that answer.
If you put yourself not in the shoes of the system, but in the shoes of a participant, in a crisis situation which creates that vulnerability, it might be, for example, in a situation of family violence. It's where does the person look for help and assistance? So in that sense, who's the provider of last resort? Where do we go? Where's the ultimate safety net? Because if there's an expectation that it's the NDIA, is that something the NDIA can actually service?
So I'm just making a distinction. I'm making a distinction between where do they go for the coordination and the support to solve the problem, and who is the provider of a particular solution. So in that situation, they can and should be calling their support coordinator and the NDIA through either our contact centre or directly through the branch contact, the LAC contact that they will have. As I said, we have processes and approaches through that critical service issues response to deal with that, because that is a reasonable expectation that involves coordination with state and territory services, and the actual provider of where are they going to sleep maybe tonight or next week or whatever may well come from a range of different parties.
Right. Would you accept that as the person in the middle here, the participant, not knowing where or how that all will work in a crisis situation is something that needs to be clarified? There could be some simplicity in how and what a participant does in those circumstances?
Of course, a participant, and any person needs and benefits from that certainty and that clarity. Given that we deal with these sorts of critical service issues very often, while not claiming perfection at all, we do have a process. It is used regularly to support people.
Right. Do you accept that the current model, which gives the NDIA the responsibility of planning and funding, is not something that can be done in isolation in looking at safeguarding and identifying vulnerability? Can't separate out the function.
No, and I think we've had a good discussion about confirming that planning and the discussions that go with that are an important part of safeguarding, yes.
Right, so just mindful of the time, I've got two issues that I want to raise with you before we end. And the first is about community visitor schemes.
Yes.
And you say at page 14, paragraph 82 of your statement, that the NDIA notes the merits of a proactive system of identifying and visiting vulnerable participants in the form of a community visitor scheme is currently under consideration. Now, can I ask you about this? You've seen Mr. Robertson's recommendation, and he makes a recommendation, I think, number 4, about community visitor scheme.
Mm-hmm.
And have you also seen the review undertaken by Westwood Spice in relation to community visitor schemes? If you want to have a look at it, it's in that volume D behind tab 6. We've included for the Commissioners a copy of the report. You may or may not be familiar with it.
I'm aware of it, but I wouldn't claim to be familiar with it.
And the Westwood Spice says there's been some form of community visitor arrangement in Australia since 1843. And I think there's concern that it shouldn't take to 2021 for that to now go. Now, you say it's currently under consideration. Can you assist the Royal Commission as to what consideration is being given to a national community visitor scheme, if that's what you're referring to in paragraph 82?
So this is, paragraph 82 is a reference to the work and the commentary that Graham Head has made, a reference to the review of the Quality and Safeguards Framework, which I understand is or should be, will be the vehicle for the consideration of this issue, as well as the continuation of the arrangements currently in place.
Well, what does that mean in practice? Will there be a community visitor scheme?
That's not something for me to decide and to confirm as to how that will be done. That's a matter for the processes through the Ministerial Council and the framework review, the Quality and Safeguards Framework Review.
I think there's been some suggestion, just thinking about the Anne-Marie Smith circumstance, about having an opt-in model for community visitors to visit people in private homes. Have you got a view on an opt-in model?
Councillor, I haven't given it a huge amount of thought for exactly the reasons that I gave before. However, one could well see how something like that could work, and we've envisaged in our planning processes and conversations that would be a good vehicle for asking people, would you be prepared, would you like to have someone and come and knock on your door from time to time? Yes or no? Yeah.
Right. The final question is about the information sharing between the NDIA and the NDIS Commission, and we asked you some questions in the matters that we sought your evidence on. So this is page 18, paragraph 101 and following, and then you've made the additional point in the corrigendum that we've received today. So what do we take by this evidence in terms of this Royal Commission understanding what information is shared with the NDIS Commission? And can you just assist us with your paragraph 101A? Because as I read that when data was initially provided to the NDIS Commission, it did not include the name and address of a participant. And in mid-2020, the names of participants were provided, but the NDIS Commission could could only provide the information to the NDIS Commission's data team. If that's right, isn't that creating a fairly significant limitation on the NDIS Commission to be able to identify particular participants by name and address? So can you just help me a little bit in understanding about this information sharing and the nature of the data that has been shared?
So that 101A is giving the timeline of changes and improvements that have been made. When the name and address was not provided, the NDIS participant number was provided as the identifier. And I think this reflects a initially conservative view about the sharing of information back then, and a progressive realisation by Mr. Head and myself that we needed to and could do more, and hence the progressive improvements, including to since early 21, both in terms of the amount of data, the nature of the data, and the frequency. Of course, the government then has now introduced a bill just this week or last week to put beyond any doubt the ability for the full sharing of data as between our two agencies, and I think that's a great thing. And then can also confirm, as I think referred to in some of these paragraphs, paragraph 105, so that enhanced ICT infrastructure is on track for delivery at the end of June. So that will enable direct, real-time access interrogation of our participant database by Commission staff, another further step. And then can also confirm that also in June, we will add further to the sort of data that is provided, which will be some of those vulnerability risk flags that we've previously spoken about earlier this afternoon.
Coming back to the vulnerability participant framework, will there be a way of data to be shared that specifically identifies a cohort of NDIS participants who satisfy the elements of vulnerable participants? Would that be part of that, just rather than just here's the name and address, but actually identify?
It will have the name and address, and it will have flags or tags against those criteria or those attributes that go to risk and vulnerability, yes.
Right. Commissioners, Mr. Hoffman has prepared a comprehensive statement. There are a large number of documents. We haven't gone through all of them today, but they'll be part of the material available to the Commissioners. Those are my questions.
Thank you very much. I shall ask the Commissioners whether they have any further questions of you, Mr. Hoffman, and then I'll ask Ms Downs as to whether she has any questions to ask you. So first, Commissioner Bennett, do you have any questions of Mr. Hoffman?
My questions do also go to data sharing, but in a slightly different nuance from Senior Counsel. In the review that was provided on Miss Smith's death, 2 points that I read was that the transfer documents weren't actually accessed at any point in time, and the first focus of the first plan was about transitioning rather than making an individual plan. So the words were used that there was a continuity of service rather than actually working out it was the right plan. There are 520 participants in South Australia that will transition by the end of the 22-23 financial year. Ms Gale said on information sharing that there needed to be an improvement between the NDIA and the Quality Safety and the state and Commonwealth agencies. Will you be aiming that there is actually full, appropriate transfer of information, not just a piece of paper that goes into a system that may or may not be read, as a learning from the Miss Smith exercise event?
Thank you, Commissioner.
Sorry, can I just intervene there? And I'm sorry to do that. Commissioner, we haven't sought to ask Mr Hoffman any questions about the content of the NDIA's internal review. There's some reasons for that. So
I was referencing the information sharing advice from Ms Gale, where she said that increased information sharing will enhance the safety of vulnerable NDIS participants. And they're the 550 she was specifically. I can ignore the component where I added more information.
Thank you.
If we could
Ms Downs can address any concerns about that.
Yes, thank you, Council. I was taking the question to be the second half of it about going forward. Thank you. And yes, it is absolutely our intention, particularly that it is now a relatively small number of people and some of probably the more complex end to do that in as good a way as possible. I've been very focused on completing full information sharing agreements with the South Australian Government. I wrote to the South Australian Government back in April wanting to accelerate the completion of the upgraded framework. We have an information sharing under the bilateral that all just goes through DHHS, but as we've heard, there are other agencies that it would benefit to have direct sharing with, such as the OPA. So I've been pushing that, wrote to the head of AGD here in April, got a good response back. We have schedules from a number of agencies, including OPA, that we're working through now. So I'm focused on that and believe we will have a good solution in place and we will do well by those participants over the coming year or two.
Thank you.
Thank you.
Commissioner McEwen, do you have a question?
No, thank you.
Thank you.
Thank you. Mr Hoffman, I'll now ask Ms Downs whether she has any questions to put to you.
No questions, thank you, Chair.
Thank you, and I assume no other legal representatives wish to put any questions to Mr Hoffman. In that case, Mr Hoffman, you'll be pleased to know that you hold the record for the longest uninterrupted evidence given by a witness. When I say uninterrupted, I mean uninterrupted by adjournments, not uninterrupted by questions from people other than senior counsel. So thank you very much for coming to the Commission to give evidence for such a prolonged stint. We appreciate your assistance, and that includes the details in your statement with which you have provided us. Thank you very much.
Thank you for the opportunity, Commissioners.
Ms Eastman, is it opportune to adjourn until tomorrow?
Yes, it will. And can I just indicate that any witnesses who've taken questions on notice or indicated that they'll provide additional information, that you'll make some directions for the timing of that. And we don't expect Mr Hoffman to prepare that material overnight.
It's state of origin.
Well, then maybe I might reinstate that it should be done overnight. All right, thank you, Chair.
Yeah.
We're going to adjourn till 10 tomorrow.
I should say I don't regard the state of origin as an excuse. It would be different if it was the AFL Grand Final. All right, we'll adjourn until 10 o'clock Adelaide time tomorrow.
The Royal Commission is adjourned.